Good morning, everyone. I'm Dayton Wood, Chairman of the Jamaica Developers Association. Welcome to the JDA's sixth webinar in the series, Building Jamaica. Today's theme is navigating the minefields in development. That thus far we have shakily navigated those minefields, we must give thanks. Please join me in a short prayer. Omnipotent, omniscient, omnipresent God, unto whom all hearts be open, all desires known, from whom no secrets are hid. Cleanse the thoughts of our hearts by the inspiration of thy Holy Spirit, that we may perfectly love thee and worthily magnify thy holy name. Amen. Yes, good. Welcome again. A special welcome, of course, to and thanks to Minister Delroy Chuck, Minister of Justice, for taking the time to once again address our meeting. Our moderator for this morning is the very erudite Krishna Desai, a partner at Miles Fletcher and Gordon. He has a wide range of experience, having been a litigator and now as head of the conveyance department at his firm. Thanks, Krishna, for taking on this role. We will be enlightened by presentations from Alton Morgan and Lisha Ann Smith on restrictive covenants, and by Robert Fowler on the role of the architect, completion certificates. My grateful thanks to them for participating in such a meaningful manner. The presentations will be augmented by very knowledgeable panelists in the legal and architectural fraternities. My thanks to you for joining us this morning. Of course, this series of webinars would not be possible without the generous support of our sponsors and of you who have registered, paid a small fee, and devoted the time to listen and be informed. May what we learn today be of true benefit to you and the business of building Jamaica, the land of wood and water. Krishna, welcome and over to you.
Good morning, Mr. Chairman. Thank you. And I noticed you emphasize the land of wood, and that might suggest some sort of bias on your part. But I would like to introduce our speaker for this morning, our opening presentation. Delroy Chuck is a Jamaican lawyer, journalist, and politician. He is currently the MP for St. Andrew Northeastern and the Minister of Justice. Mr. Chuck previously served as Minister of Justice from 2011 to 2012 and as Speaker of the House of Representatives from 2007 to 2011. Mr. Chuck joined the Jamaica Labour Party in 1995 and first contested the St. Andrew Northeastern seat in 1997, an election in which he was victorious. He has held this seat ever since and won his fifth term in Parliament in 2016. Mr. Chuck is of Hakka ancestry, and I hope he will tell us something more about that. And his birthplace is in Christiana in the parish of Manchester. But he grew up in Clarendon, where he attended Rich's Primary School from 1955 to 1962, where he was successful in his common entrance examination. He then attended Kingston College from 1962 to 1969, and during his tenure at KC, he served as deputy head boy, president of the Interact Club, and he was an active member of the chess and lawn tennis clubs and represented KC in both sports. He left KC with 5 A-levels and a scholarship to UWI, where he earned a BSc with honors in special mathematics. In 1972, Mr. Chuck was elected the 1973 Jamaica Rhodes Scholar and attended St. Catherine's College, Oxford, from 1973 to 1976, where he studied law and graduated with a BA in jurisprudence and a Bachelor of Civil Law degree. So I'd like to welcome Mr. Chuck to give us our opening address this morning. Mr. Chuck.
Thank you for thank the Jamaica Developers Association for once again inviting me to deliver the opening address. I do consider it a privilege and honor. The Jamaica Developers Association should be congratulated for discussing topics that are vital and important to developers. I'm sure those who participate will benefit from the contributors who are experts and professionals in their field. The Developers Association is definitely a body for highlighting the challenges and issues its members encounter and seek to find solutions that are beneficial to them. Instead of primarily competing, members of the association could collaborate and cooperate even more for their mutual benefit. At the outset, let me thank the many developers who, over many decades, have provided lovely residential homes for thousands of Jamaicans. Jamaicans are truly appreciative of the many developments, small and expansive, that have allowed so many families to live in comfort. Over the years and numerous times, I have lived in Harborview, Mona Heights, and Hope Pastures, and truly admire these developments, which, after 50 years and more, have withstood earthquakes, hurricanes, and man-made disasters to accommodate and continue to allow thousands of Jamaicans affordable and comfortable living. To be sure, there are similar schemes, some even more extensive, that provide single-family units with green space, trees, and children playing areas. Yes, in rural parishes, these single-family scheme homes with reduced yard space are still being built. However, in urban areas, the trend is towards multifamily developments where hitherto single-family units existed. No one can deny the need for these multifamily, high-rise apartments and townhouses. Yet there's an urgency to re-examine if and where these multifamily developments on limited land space should emerge. I will discuss that later. At this time, many residential communities are fearful and resistant to these emerging developments. At the same time, developers should be aware that the public at large are busily and respectfully scrutinizing their developments and the seemingly intrusive manner in which these developments emerge, especially in Northern St. Andrews single-family residential communities. Surely, these residents, many are retired and endeavoring to enjoy their retirement, deserve to have their peace of mind and bereft of the demand to protect the restrictive covenants to which their properties are entitled. In Upper St. Andrew, most homes were built less than 50 years ago and are generally part of a scheme governed by restrictive covenants. On reflection, is it fair to these residents to have these multifamily, high-rise units springing up contiguous to their homes, which were hitherto private and with unrestricted view and in an unobtrusive setting? In truth, residents are extremely annoyed, angry, and amazed when, without notice or warning, and most times without knowledge of any amendment to or application to amend the restrictive covenants, multifamily developments simply spurt up totally unannounced. Residents should never have to suffer the inconvenience or expense to challenge these applications to modify restrictive covenants to which, as homeowners, they are entitled. I strongly believe that restrictive covenants, being contractual arrangements between homeowners, should only be modified with an express, implied, or constructive agreement are a significant majority of all homeowners agreeing. It is simply not right that development should begin even before the restrictive covenants are modified. At which point, the developers fervently believe that having spent huge sums to get municipal approval, they can override and overpower every homeowner's objections to the modification. This impasse needs to be resolved. Our courts should not be demanding that there should be an approved development plan, which may have cost millions of dollars before considering the application for modification. Surely, a sketch plan should be enough. This costly impasse is a matter that needs to be resolved. I am aware that the vast majority of developers, especially those who are members of this Jamaica Developers Association, do follow the rules and sadly get shafted by long delays and obvious frustration. Still, there are far too many developers, especially those who are seeking to launder ill-gotten gains or to make quick money from ill-conceived developments, who are making residential and neighborly living inconvenient and an unholy mess of perennial dust, heavy equipment disturbance, and road disrepair. Developers, especially members of this noble association, the reverberating discussion nowadays is about codes of conduct. Should developers have one? I think it is most appropriate that they should do, and that there should be some minimum quantitative measurements by which developers can be judged and held. While we appreciate that developers engage contractors to build houses, to invest and to make a profit, and to create surplus and gain experience for other developments, it is extremely important that construction should in some way benefit the neighborhood and not be destructive and damaging to it. Yes, while a pleasing and well-appointed development can lift and improve the ambience and value of the neighborhood, the reverse can be the actual reality when the neighborhood can become overcrowded, congested, and a seeming concrete jungle. Again, on construction sites, there should be minimum standards of behavior, noise, neighborly interaction and dislocation, and prompt continuous repairs to roads adjoining and leading up to the development. It is absolutely wrong for the developers to blame the contractors and or their workmen. It is absolutely wrong to ignore the privacy and convenience of neighbors who suffer continuously during most constructions. It is absolutely wrong to leave the roads and sidewalks in a worse state of repairs than originally found. Indeed, at a very minimum, developers should ensure that order and regular cleaning in and around construction sites are maintained from commencement to completion. It is such a pleasant surprise to observe the cleaning, improving, and repair to roads and sidewalks during a development and after, such as on Braemar Avenue, after the completion of the Hampshire Apartments. Far too many developers are totally ignoring the conditions attached to their development approval. Should the municipal corporations demand bonds, which could be used to force compliance with the imposed conditions? Alternatively, the municipal corporations could require a no objection letter from the Member of Parliament and or the councillors before providing any letter or approval authorizing the issuing of splinter titles. Such no objection letters should not be unduly withheld and could be overridden by the city engineer in appropriate cases to avoid any perception or reality of corruption. However, when things go wrong and roads and communities are destroyed and severely disrepaired, it is the councils and the MPs who are called upon to fix them and to do so promptly. Moreover, at various times of the construction, the councils and the MP in particular are blamed for not managing and instructing the developers to clean the roads, to avoid the congestion, and to stop the noise at various hours of the night and on weekends. So, as a member of parliament, one of the major grievances that residents bring to my attention is the damaged and disrepaired roads, primarily caused from concrete and heavy-duty trucks traversing across them. When anyone drives on the corridors of Dillsborough Avenue, Millsborough Avenue, Tavistock, and Jackson, it is appalling to observe and note the multi-billion, with emphasis, multi-billion dollars developments from which developers have made hundreds of millions of dollars. And to date, no one has ever offered to fix even a part of any of these roads on which the purchasers have to drive to and from their new homes. Surely, these developers could combine and provide carpet roads befitting the quality of the luxury homes developed alongside them. Developers, I await calls from these developers around this corridor to repair the roads. Carpet roads would suit these developments, but I don't expect any. Frighten me, surprise me, and call me as to how we can put together to make Millsborough Avenue, Dillsborough Avenue, Jackson, Tavistock, really carpet roads. So while I appreciate that developers are primarily concerned with the speedy completion of these projects and to optimize their profits, I urge developers to escape from these narrow visions and widen their vision to include human, community, and national developments. I acknowledge that any development contributes to social and economic improvement. However, it can be more focused and beneficial. We can do more for the people who help us to make our ventures succeed and realize enormous profits. How many developers check to determine if the workmen in and on their sites are trained and certified? Would it not be useful to assist these workmen to get certification from the Hard Trust NTA? So many masons, carpenters, plumbers, tilers, painters, etc., move from site to site and even remain with the same contractor and have no certification. In the modern age, certification is vital for any employee. And as a rule, developers should endeavor to have trained and certified workmen to ensure the construction is properly and professionally done. But most importantly, to assist with certification is to assist the workman with the opportunity to move on to other jobs without the need for recommendation and contacts. I do not deny that workmen are contractors in their own right and responsible for their personal well-being. Still, is it possible for additional training and information to be provided to help them to develop into true professionals and good citizens caring for their families and children. Sadly, at many of these sites, disputes and disagreements drift into violent confrontations and unnecessary personal injuries. If developers are interested, the Ministry of Justice will provide free sensitization program in dispute resolution to workmen to alternate ways and means to resolve disagreements and restore relationships. And the ministry will do it free to participants as we pay the instructors. Finally, I turn to the crying and urgent need for urban renewal. Even while the government contemplates and studies how a sustained program of urban renewal can be undertaken, developers should start to reimagine and to plan how our inner cities can be renewed and rehabilitated. More importantly, there are many pockets of the decaying households that cry out for joint ventures with the owners or occupants to rehabilitate and develop the areas. In my constituency, I can think of the area between Russell Heights and Birdsucker Lane and other surrounding communities. Still, developers should start eyeing vast swaths of older communities across the whole parishes of Kingston and St. Andrew, where many houses now decaying and need to be replaced. Actually, it is in these older communities that modern high-rise family apartments, multifamily apartments, should be constructed. One hopes, however, that developers should eye 5 to 10 acres of vast swaths of properties that would allow several high-rise apartments, but also enough land for trees, green space, playing facilities, and space for community activities. I would like to see the owners and occupiers in these areas, for example, Vineyard Town, Rollington Town, Almond Town, etc., be engaged in joint ventures with the developers and the government for an orderly and creative process to build new and well-appointed complexes and communities. Eventually, the government may well be invited to declare designated areas available for urban renewal and allow developers to engage homeowners to enter into joint ventures. Thus, developers could offer homeowners, in exchange for their properties, 2 or 3 brand new townhouses or apartments in the new development. To be sure, some owners may simply want to sell and put everything behind them. There are others who may refuse to sell and want to remain undisturbed in their present abode, regardless of how dilapidated or decaying the property may be. Accordingly, the government's intervention becomes necessary in the instances where it is necessary to acquire the property for new development. The process of eminent domain is well known, but rarely used for the benefit of housing developments. I expect that if urban renewal is to gain speed, developers may need to have the government use the tool of eminent domain to ensure orderly and comprehensive renewal of urban and blighted communities. Developers across our inner cities, our people deserve better living conditions. Government alone cannot do it, or even able to provide the funds to help these inner city citizens. And the vast majority of the citizens cannot and will never find the funds to rehabilitate their homes, much less their community. As I close, I urge developers to think and to reimagine how our urban areas could become and start planning with the National Housing Trust, other government agencies, and central government to fund and find ways and means to redevelop Jamaica and provide homes for our people. I thank you for this opportunity.
Thank you, Minister Chuck. I think you have expertly set up the context of today's seminar, and we have all heard your statements in relation to the needs of the Jamaican society, the concerns of citizens, and the role of government to enable and also to provide for proper environment and planning for cities and towns and rural areas, all leading to sustainable, orderly development of Jamaica. So we'd like to thank you for setting that context. We are going to move to a very short commercial break.
Right. Thank you very much, and have a good seminar.
Our first panel. All right, Mr. Chuck, thank you so much.
Bye now.
So we're going to move to a very short commercial break for about 1 minute.
Capture all the sweet moments in your own sweet home. Up to 100% financing from JN Bank will get you there. Get pre-approved now. JN Bank will help you find a way.
For almost 40 years, the GEON Group of companies have been developing plans, laying foundations, building hundreds of homes of distinction, creating exclusive and secure communities in which we live, play, and raise families. The GEON Group of companies, creating homes that people enjoy.
DigiView Security Limited. Operating for almost 15 years, DigiView Security Limited is one of Jamaica's premier electronic security solutions providers. DigiView offers top-of-the-line solutions and services to protect your home and business in the ever-evolving electronic security industry. AI features: perimeter protection camera, human detection and line cross, license plate recognition, panoramic 180-degree camera, 360-degree camera, face recognition, intelligent search and playback functions. DigiView Security Limited. See what you've been missing.
I light up the streets, I light up the beat, I light up the place where we meet and greet. I for what they think, them will make life sweet. I light up the church where the pastor preach. Light up the good times in the service, forward the music in the worship. Light up the moments that matter, light up the laughing and chatter. Light up the net and the rocket, light up the score so you know who got it. Forward the socket, now stop it. Light up the path so you don't lose your way. Light up the field so you don't miss a play. Every night, every day. Light up the path so you don't lose your way. Every night, every day. Light up the field so you don't miss a play. Every night, every day. Light up the party from now till it's done. Every night, every day. Bringing light to everyone.
Welcome back, folks. Ahead of our first panel, we're going to have an address by one of our platinum sponsors, JN Bank. And I would like to introduce Mr. Earl Samuels, who is the Chief Development Financing Officer of JN Bank, to address you briefly. Earl has had a long relationship with the JDA, having served the JDA in different capacities and having been involved in the development sector in Jamaica for some time, including through the National Housing Trust. So if we can welcome Earl Samuels to give us a presentation on behalf of JN Bank. Earl?
Thank you, Chairman. I'm not sure if Honorable Delroy Chuck is still with us, but I greet him and fellow panelists, participants joining us online, and the distinguished guests, ladies and gentlemen, good morning. The real estate development sector continues to enjoy a boom across the country, in particular the KMR and the North Coast. We have also seen changes in the type of development in the corporate area to a lot of multi-story type structures. The construction industry remains resilient, and we know that even during the COVID pandemic, most of us were stuck at home. The industry still continued to contribute to the economy. However, While there is much to celebrate, there's also much to address if we are to reap future successes. These are among the reasons I'm pleased to join you all here for this JDA seminar, which brings together an experienced group of professionals to lead discussions on one of our country's critical industry. I believe your theme for this year, navigating the minefields in development, is important because there are challenges that have been affecting the development locally. JN Bank recognizes that we have a pivotal role to play in orderly development and the success of the real estate sector in particular. And therefore, we are happy to provide short-term to medium-term development financing to developers, and at the back end to provide long-term mortgages to the purchasers of the units. And as you have seen on our commercial, we're providing financing to up to 100% to the purchasers of the units. However, we have some concerns about as we assess requests for development financing, we have some concerns about the reliability and the quality of information provided by some developers when seeking financing to execute their projects. We continue to receive statutory approved documents which are inconsistent in the information they provide. You have documents not for the same project, not providing inconsistent information. We also see bills of quantities for projects which are inconsistent with the scope of the project to be developed. Project budgets are also sometimes understated because all of the costs for the development are not factored into the project. And possibly one of the reasons for this, for development financing, we provide up to 80% of the total project cost for residential development. And for commercial development, we provide up to 70%. And as we peruse some of these budgets, we realize the gross inconsistency based on the scope of the project and the overall project cost. We're also experiencing some challenges, which I think this is the right forum for us to address it. And I will hear from my good friend Bob Fowler later, where at the mortgage end, we are getting practical completion certificates. And these are on the certificate which we disburse the mortgage over to the developer's attorney. But we get complaints from some of the purchasers that the units are not habitable. And when we send our officers out to inspect, indeed, some of these units are not habitable. So I want to use this opportunity to appeal to the professionals in the sector to ensure that we work together so that we can build a resilient housing development sector. JN also provides opportunity to the developers through what we call our developers program, where if you are registered in the developers program, your project is exposed to our entire customer base, which is over 800,000, both customers locally and in the diaspora. And we will work with you to ensure that these persons are pre-qualified so that the whole sale and conversion to mortgage process can be very smooth and seamless. Once again, JN is happy to work with the developers to ensure that we have a successful housing development, construction industry. Thank you.
Sure. Thank you, Earl, for those remarks. And also, again, thank you to JN Bank for its sponsorship of today's event. JN Bank and also Gore Developments Limited are the platinum sponsors for today's seminar. I'd like to also thank the gold sponsors, DigiView Security Limited, Gion Group of Companies, Jamaica Public Service, National Housing Trust, and we have silver sponsors, Caribbean Cement Company, Jamaica Money Market Brokers, Matalon Homes Limited, West Indies Home Contractors Limited, and our bronze sponsors, Jamaica Mortgage Bank, Jamaica Property Company Limited, Millennium Properties Limited, and the Sagicor Group of Companies. So we're going to move into our first panel, and there are two panelists I'd like to briefly introduce to you all. And this panel is going to be making a presentation. So there are really two presenters, followed by a panel to discuss their presentation and to take questions from you all. The presentation is going to be the developer's dilemma, pre-development restrictive covenant modification. And our two presenters are Mr. Alton Morgan and Mrs. Lysiane Smith. Alton has over 44 years experience in real estate practice. He's an associate member of the JDA for over 20 years and has served on the National Land Agency Advisory Board. And he has also served on Jamaica Chamber of Commerce's Legislation and Regulations Committee and the Land Divestment Board. Alton is a legal advisor to the JDA and the attorney for several of the long-standing premium property developers, which are JDA members. Lysiane Smith is a partner at Nunes Schofield de Leon & Co. And she's the partner in the firm's conveyancing and probate practice areas. And she joined the firm in 2003. She has gained significant experience and knowledge from representing clients in many varied transactions and currently handles transactions on behalf of one of Jamaica's leading residential property developers. She's the firm's representative with the JDA and is the JDA's representative with the PSOJ. She's a member of the Jamaica Bar Association. Alicia has garnered significant experience in the sale and purchase of real estate and has had to resolve many complex issues during the process of such transactions. Her practice spans a wide range of land-related matters, and she also attends courts on behalf of clients in respect to applications to modify restrictive covenants which have been breached. She is also responsible for matters involving estate planning and the administration of deceased persons' estates, with the aim of preparing those documents which are important to achieving the client's goals. She has successfully assisted clients in obtaining grants of probate and letters of administration in their loved ones' estates, and has assisted in making applications to the court to admit copy wills to probate and applications under the Mental Health Act. So we have two very experienced and knowledgeable presenters. I would ask everyone to take note of what questions or comments they would like to make. I believe we have a chat feature which we'll use to raise questions with the presenters and the panel after. And if you'd want to address them after, we could also accommodate that for you. So I'm going to turn over to the two panelists to deliver their presentation, and then we can look forward to a good panel discussion right afterwards. Alton and Alicia.
Thank you very much, Krishna. Good morning to everyone. The presentation will be divided into three sections. I will start with presenting on recent decisions of the court and the overview of the law as it applies to restrictive covenant modification by developers. Lysiane will then take over and deal with what are the restrictive covenant obligations of the local planning authorities. And then I will finish off with a look at the methods that ought to be adopted by developers in making their restrictive covenant applications prior to commencing development. So Isha will be controlling the slides as we speak. Fine. Now, Mr. Chuck has rightfully touched on a number of areas that this presentation will attempt to address. And we will start by looking at recent decisions of the court, because that's what has been in the public domain and which has attracted so much attention. So recent decisions of our courts relating to objections raised by neighbors to modification of restrictive covenants affecting land are indicative of current common law, where a thing called the sociology of jurisprudence is coming to the fore. And that jurisprudential posture is apparent in a series of recent decisions where the challenge by neighbors has been vindicated by the courts. The position is not new. One of the oldest reported court rulings on an application under the 1960 Restrictive Covenant Modification and Discharge legislation, which we'll call the RCDMA from now on. One of the oldest reported court decisions was in 1966. It involved the case of an application by Federal Motors for property at the corner of Lady Musgrave and Leinster Road, and that application was refused. We find that the developers who have been stalled by the courts are not really members of the Developers Association, not JDA members at all. JDA members have been conducting business of development over several decades. And it is also noticeable that the type of real estate developments which are the subject of the negative court decisions is primarily high-rise apartment buildings. On certain suburban roads, the recent frequency of high-rise apartment developments on former single-family house lots could best be described as contagious construction. So one may ask, why is there this proliferation of apartment buildings? It seems it may be attributed to the law that restrictive covenants on a title which state there shall be no subdivision of this land do not prevent strata developments. And I know that's going to raise your eyebrows. The law is straightforward. It's found in Section 3, subsection 5 of the Registration of Titles, Strata Titles Act. And it states the provisions of any enactment other than this act relating to the subdivision of land for sale or for the purpose of building thereon shall, to such extent as may be prescribed by regulations under this act, not apply to land comprised in a strata plan. So it clearly exempts strata plans from the no subdivision covenant restriction. In essence, once an approved construction is validated and registered as a strata plan, the no subdivision restrictive covenant on the title for the land then becomes obsolete for all practical purposes. A stop order or injunction may still be issued before completion, because when a multi-unit building is erected, it is technically in breach of the no subdivision restrictive covenant if no strata plan is yet registered. This is important because a strata plan is not ordinarily approved until the buildings in the development have reached the roof level. And until the strata plan is approved, it really can't be registered at the Office of Titles. And this may mean that construction will be underway for quite some time before the strata plan is able to be registered. The developer who adheres to the requirements of the New Building Act to have neighborhood consultations will therefore be able to avoid the complaints that could trigger such stop orders or injunctions from being issued. Real Estate Board has instituted a policy to restrict registration of developments for pre-sale unless restrictive covenants that could impede the issue of individual titles are first modified and actually endorsed upon the relevant title. And the policy is reasonable as a means of prohibiting pre-construction sale of units in a development to the unsuspecting public. So attorneys are also cautious to advise clients against entering into pre-construction sale agreements where restrictive covenants have not been modified to permit the development. Bankers are now risk sensitive, as we heard from Mr. Samuels on behalf of JN. They are risk sensitive to the prospect of developments being stalled due to non-compliance with terms and conditions of approvals, and the pause of the Building Act 2019 for municipal authorities to issue and enforce stop orders, which are supported by heavy fines. And that general approach is consistent with protecting the public from consequences, such as the court's decision in Young versus the KSA, MC, and NEPA, which was a 2020 decision, re-premises at 17 Bertucker Drive. In that instance, the KSA, MC, the municipal corporation, was found to have breached its statutory duties and failed to follow procedural requirements prescribed by law, while NEPA was deemed to have exceeded its authority in granting an environmental permit retrospectively. You may also recall the Supreme Court's decision in a case involving property at Upper Montrose Road, where it was ordered that the buildings which had been erected in contravention of the covenant should be demolished. The Court of Appeal decision in that case of Heischer and others versus Lynn, where it was handed down just at the end of March, as I recall. The decision has allowed that the buildings should not be demolished. But the more important factor is that the modification of the restrictive covenant against subdivision was refused. So no separate titles may be issued for the lots unless the entire development becomes a strata plan. Well, the developer did build some strata units, so perhaps that's the way out. The need for subdivision or building approval as a prerequisite for restrictive covenant modification applications seems not to be well understood. The technical problem with first making an application to modify restrictive covenants to permit multi-unit development of any plot of land is that in the current dispensation for more than a decade, the court requires that the application may not proceed beyond the first stage until formal development approval is first given. The court is vigilant in that regard because it is enforcing Section 3, subsection 2 of the statute, which states the judge shall, before making any order under this section, direct such inquiries as he may think fit to be made of the Town and Country Planning Authority and any local authority. NEPA is the Town and Country Planning Authority, for those who wonder. And such notices as he may think fit, whether by way of advertisement or otherwise, to be given to the Town and Country Planning Authority and to any persons who appear to be entitled to the benefit of the restriction sought to be discharged, modified, or dealt with. So the court has an obligation to make inquiries and to ensure that those who are likely to be affected by the change of covenant are properly notified. In essence, it is the safeguard mechanism to ensure that before a restrictive covenant is modified, the relevant persons become involved in the process. So by Section 5, subsection 2 of the Local Improvements Act, the development considerations which the local planning authorities should consider and advise the court on are the site location of the buildings, whether the buildings meet the plot, which is landslide, to plan building size ratio. You hear word of plot to plan ratio. It's the size of the land to the size of the building. And that is for any given area of land. And we've seen in recent decisions where the area of land was insufficient to sustain the size of the building being erected. How many buildings are going to be put up, the height, their square footage, and their compatibility to the neighborhood, their design, and external appearance and the likely impact on neighboring lands. So I'm going to hand you over now to Alicia Ann, who will deal with the restrictive covenant planning obligations of the local authorities.
Thank you, Alton. Good morning, everyone. So, with respect to the local planning authorities, under Section 3.2 of the Act, the local planning authorities, essentially NEPO, and the relevant municipal corporations for the various parishes have a duty to inform the court of A, where there are known breaches by the developer of any statute which the local authorities have a duty to enforce, and B, the effect or potential impact of such development breaches on the public infrastructure in general, for example, drainage, traffic flow, waste disposal, etc. So these are some of the things that the courts will take into consideration when the application for discharge or modification is being made. Consequently, there is a duty to bring to the court's attention any existing breaches of the Building Act for the restrictive covenant application before it. That extends to informing the court whether or not a building has been built without an approved building permit, or if it has been built in a way that offends the approved building permit. I think it's for this reason that there is sometimes confusion as to the responsibility of the various agencies involved. In Belgravia Development Company Limited, v. 10 Roseberry Drive, which was a decision made in 2021, the court refused the covenant modification application because the building approval was irregular. This because, as we heard before, they were to take into consideration property size. And in this case, the property size was 1,705.281 square meters, or 0.421 of an acre in size. This rendered it non-compliant with the statutory guidelines for multi-family residential development. As with other areas of law, it does appear that there is some misunderstanding as to the role of the relevant governmental agencies in these types of applications. It should be noted that by and large, the role of NEPO and the local authorities in the development of land throughout the island is regulatory. As a result, it is their responsibility to ensure that there is compliance with the legal requirements which are set forth in the various developmental laws. This highlights the need for their inspection processes to be revamped to ensure that the supervisory functions as it relates to these developments which are under construction are properly and promptly being carried out. We've seen what happens when developments are ongoing and there is no inspection, and then the problems that sometimes arise. So, as their role in restrictive covenant modification applications is to comment and to inform the court of any breaches which are in existence and which would then assist the court in determining whether the application for modification should be granted, their ability to comment in this way is not, however, the means by which they should seek to conduct their regulatory functions, because they're already duty bound to carry these functions out. So the local authorities need to ensure that they're carrying out their functions regardless of whether or not there is an application for modification. It can therefore be understood why the local planning authorities are often reluctant to issue a no objection letter to the court for a restrictive covenant modification application when it does not have an actual development application before it for the land. The local planning authorities have a statutory duty to discharge and must avoid the embarrassment of singing that song titled, and I won't sing it, but I'm sure you know the song, "If I Knew Then What I Know Now." I believe it was it Kenny Rogers? Anyways. So the development approval need not be the final subdivision or building approval. Even outline approval under Section 14 of the Town and Country Planning Act issued from the NEPA Development Assistance Center may in some instances suffice to support the application for modification. This is for example, to facilitate bare land subdivision. So if the property is just being subdivided. Okay, I will turn back over to Alton.
Thank you very much, Lisha. So we have now outlined to you, in essence, the dilemma which developers face. What then are the methods or modalities for changing restrictive covenants for land which proposed to be developed? Well, the methodology for approaching restrictive covenants applications has an impact on the likelihood of success. It's important to appreciate that making an application to the court under the Restrictive Covenant Discharge and Modification Act is discretionary. It's not mandatory. You don't have to do it. And no one is obliged to use that method if there are other valid legal avenues for achieving the same result. So, obtaining the consent of the persons entitled to the benefit of the restrictive covenant by execution of a deed of consent, which the registrar of titles will accept, is the old common law method that existed before the statutory alternative of applying to the court was introduced in 1960. But regardless of which method is adopted, there first has to be detailed legal research of the antecedents of the specific title to identify three main things. A, the origins of the restrictive covenant and how it came to be on the title. B, whether the restrictive covenant had at any time in the past been modified by court order or amended by consent. And C, which parcels of land are entitled to the benefit of restrictive covenant and who owns them. There are only three bases on which a landowner can become entitled to the benefit of a restrictive covenant if they are not the original beneficiary of the title. One is that the land for which a covenant exists was assigned to them, or they've inherited it by direct succession. Two, there's a document which expressly confers the benefit of the restrictive covenant to the land they now own. And three, both the applicant seeking to change restrictive covenant and the likely objector each own land bound by a scheme of reciprocal rights, which is stated in the body of the restrictive covenant itself. Now, I can tell you the research is so vitally important because recently in conducting a title investigation for restrictive covenant modification, we discovered that the no subdivision covenant had in fact been modified in 1964. So we were discovering this 60 years later, almost 59 years later. The modification had been done to permit 80 lots on the title. This is in the Seymour Lands area, which will cause you some surprise. What had transpired was that the old title had been lost, and due to an oversight, the modification had not been endorsed on the new title, which was issued to replace it. So all that was needed to change the covenant was a correction of error application to the registrar of titles. But it underscores the importance of doing thorough research to go to the very root of the title. In 1960, when the statute for modifying covenants came into effect, it came with a set of rules and regulations. Those rules not only prescribed that an objection could be raised by neighbors, they required that an objector state what quantum of compensation they required for the loss they would suffer in the event that the court granted the covenant application. In fact, the rules carried a certificate of compensation, which had to be signed by the registrar of the court before the order could be registered upon the relevant certificate of title. And that rule is still there. The consent of neighbors is contemplated by Section 3, subsection 1C of the Modification of Covenant Statute, which provides a ground for granting modification of the covenant that persons of full age and capacity from time being or from time to time entitled to the benefit of the restriction, whether in respect of estates in fee simple or lesser estates or interest in the property, to which the benefit of the restriction is annexed, have agreed either expressly or by implication or by their acts or omissions to the same being discharged or modified. Established developers, whom are mostly members of the JDA, have followed that process and interacted with the persons in the neighborhood that would be affected by their proposed development to get their feedback and cooperation. It sometimes has led to changes in the design of the proposed development, and invariably there is a degree of cordiality and compromise that has resolved the issues which would otherwise have caused formal objections to be raised in court. Experienced attorneys representing those developers would produce special consent to modification of restrictive covenant documents that would confirm the wording of the modification of restrictive covenants that has been agreed on and have them produced to the court. And of course, any compensation arrangement would be negotiated and undertakings given to ensure that they would be honored. In February of 2003, a new set of court rules were gazetted to bring the process for restrictive covenant applications into alignment with our new civil procedure rules of the Supreme Court, which had come into effect in 2002. So that was 21 years ago. What is important is that the 2003 rules do not erase the 1960 rules in their entirety, and they do not interfere with the methodology for neighborhood consultation and consent, which was established over half a century ago. Well, why do we have the problems now? Because disregard for the old neighborhood consultation process preceding development is an unfortunate practice which has emerged in the last 2 decades. There is no doubt that it has raised the level of objections to restrictive covenant modification applications. The non-consultation may be attributable to the influx of first-time developers who prefer to remain anonymous and do not wish to become known to the neighbors. The change was noticed by Parliament, and sections 18 to 23 of the Building Act specifically mandate pre-application notices to be put up on site and a neighborhood consultation process. The notices are put up, but the neighborhood consultation required by the Building Act, sections 22 to 23, is generally being ignored at the risk of invalidating the final approval. We come now to look at the character of a neighborhood. There's a tendency to believe that because of a few proximate multifamily developments along a roadway, that the character of a neighborhood has changed. That is not necessarily so. The court has a very specific test for determination of a neighborhood known as the estate agent test. And essentially, it asks the question, what would a purchaser of a particular property in this neighborhood expect to get? Now, interestingly, a single road can be split into 2 separate neighborhoods on either side. The court ruled to that effect 38 years ago in the case of Regardless Limited versus Hadid and Chang, re 48 Norbrook Drive. There it was determined that properties on the southeastern side of Norbrook Drive, bounded by the golf course, were of a different neighborhood from those on the northwestern side, which had a ravine and paved gully behind them. So the expertise involved in the restrictive covenant modification process for development has unfortunately been disregarded in the choice of legal representation. But there is guidance, because when you read the court rulings on the various applications, it is apparent that the text of Preston and Newsom on restrictive covenants is regarded by the court as the authoritative text on the subject, and they often refer to it for guidance. So, unfortunately, in dealing with the character of a neighborhood, the common approach we see being taken by most in the profession, who apparently don't have the experience, is to simply jump straight into a court application under Section 3 of the statute without any prior neighborhood consultation or in-depth research to establish the genealogy of the specific restrictive covenant which is to be modified. The Supreme Court weekly list shows an average of 60 restrictive covenant modifications each week, about a dozen per day. We even have a special master who sits just to hear those applications. And of that number, perhaps 10% relate to covenant modification to permit developments. So we look now at Section 5 of the Restrictive Covenant Discharge and Modification Act, which says the Supreme Court shall have power on the application by motion of the Town and Country Planning Authority or any person interested, which would mean the owner of the property or the one seeking to have it developed, to declare whether or not in any particular case any freehold land is affected by a restriction imposed by any instrument, or to declare what upon the true construction of any instrument purporting to impose a restriction is the nature and extent of the restriction thereby imposed, and whether the same is enforceable, and if so, by whom. So that provision in the law, Section 5, is very important because it allows that an application may be made to the court to determine if a restrictive covenant has in fact become obsolete, or if not, who are the persons still entitled to the benefit of that covenant that you would seek to modify. And as pointed out before, there are only 3 bases on which anyone can claim to be entitled to the benefit of a restrictive covenant. In the absence of neighborhood consultations to obtain consent or non-objection, and to avoid any likely objections, a Section 5 application is where the developer should start. If that process isn't taken, then to engage simply by going for Section 3 is to start practicing Russian roulette with the outcome of that application. The case of Half Moon Bay versus Crown Eagle Hotels, which began in 1995, was an application under Sections 5 and 6 of the statute to determine if the land was a beneficiary of a specific restrictive covenant. And it culminated in the Privy Council's decision in 2002. And that decision gives an excellent analysis of the law. So the recommendation, therefore, is that serious developers may avoid the dilemma of restrictive covenant applications being refused by adopting certain best practices. And those best practices are starting the process with an advisory opinion from an independent lawyer, realtor, and planning architect. It always amazes me that people will go to their doctor and get second and third opinions before taking on surgery. But those who want to develop land at substantial cost of hundreds of millions don't think they need to get a second opinion from an expert. There's need to engage competent legal expertise. There's no doubt about that. It's not all and sundry area of practice. It requires persons who have been at it for some time. Usually they come out of large law firms where that is a feature of the practice area of that firm. And the knowledge base which is required is substantial. There's need to conduct neighborhood consultations. If you're going to be doing something in a neighborhood, then speak to the neighbors. That's common decency, actually. But the law now mandates neighborhood consultations, and to avoid it means doing so at your peril. And of course, there's a question of conforming with the approvals which are granted, because as Lishan pointed out, even if you do have the approvals, if you have not conformed to what they prescribe, then the authorities can object or report you to the court. And in essence, your application will fail. So bearing in mind, in conclusion, having regard to the huge sums of money involved in the development process, the correct approach to restrictive covenant modification has to be made a priority. It can't be oh, we'll get to that in due course. Let's start the construction now. To do otherwise may be the equivalent of just going to the casinos in Las Vegas, taking a huge gamble. Thank you.
Thank you, Alton and Lysian, for that presentation on the developer's dilemma, pre-development restrictive covenant modification. Very interesting. I especially like the stats you mentioned there, Alton, of the number of applications before the court and how many of those are for developments. We are going to have a very short commercial break. We are then going to go into a panel discussion where our presenters are going to be joined by 3 panelists. So if you just bear with us for about 2 minutes, and then we'll start our panel, and you should get your questions ready for either presentation in the chat, or you can ask directly on the mic if you raise your hand. All right, no problem. So let's go for a short commercial break. We'll be right back. Thanks.
Capture all the sweet moments in your own sweet home. Up to 100% financing from JN Bank will get you there. Get pre-approved now. JN Bank will help you find a way.
I light up the streets, I light up the beat, I light up the place where we meet and greet. Half of what they think, then we make life sweet. I light up the church where the pastor preach. Light up the good times in the service, power the music in the worship. Light up the moments that matter, light up the laughing and chatter. Light up the net and the rocket, light up the score so you know who got it. Power the socket, now stop it. Light up the path so you don't lose your way. Light up the field so you don't miss a play. Every night, every day. Light up the path so you don't lose your way. Every night, every day. Light up the field so you don't miss a play. Every night, every day. Light up the party from now till it's done. Every night, every day. Bringing light to everyone.
For almost 40 years, the Gion Group of companies have been developing plans, laying foundations, building hundreds of homes of distinction, creating exclusive and secure communities in which we live, play, and raise families. The Gion Group of companies, creating homes that people enjoy.
The Guaranteed Purchase Program is an initiative of the NHT to bring more houses faster to contributors. Under this agreement, the NHT will purchase housing solutions from developers for resale to its contributors. The GPP offers win-win solutions for everyone: the developers, the NHT, and most importantly, the contributors.
Okay, folks, welcome back. So our presenters are going to be joined by 3 panelists. I'm going to introduce each of the panelists briefly. The first is John Leiber. He's an attorney at law consultant at Duncox. He has considerable experience in several aspects of law, mainly in conveyancing and commercial law. John has served as the president of the Jamaica Bar Association and the chairman of the legal committee of the Real Estate Board and Strata Corporation. He has also served on several boards, including the Manufacturers Merchant Bank, Caramed Limited, and has been involved in several divestments, including that of NCB, Cement Company, and Versaire. John presently uses the expertise and contacts he has acquired from these varied areas of practice to resolve complex problems in subdivision and commercial transactions. He's presently a member of the JDA. He's the chairman of the Scouts Association of Jamaica. He's chairman of St. Jago High School Foundation, and he's the manager of the St. Jago High School track team, which is one of the largest programs in the island with several Olympians. John is the chairman of the firm's Pension Fund and Office Management Limited, which is the real estate arm of Duncox, and a member of the Jamaica Amateur Athletic Association, Special Olympics Jamaica Limited, and the Jam Damas Running Club. Joining John is Mrs. Rose Bennett Cooper, attorney at law with the firm Bennett Cooper Smith. She is an experienced attorney at law with over 30 years of expertise in land use and development litigation. Rose has appeared as lead counsel in various courts, including the Supreme Court, the Court of Appeal in Jamaica, and the Privy Council in England. Rose is recognized as a pioneer in the town and country planning law. She provides pro bono training on building breaches, zoning, and environmental matters, and has worked as a consultant to the government of Jamaica and international development organizations. Rose serves as an advisor to mayors, to ministers of government, and to city managers. She has held significant positions in, I lost my feed. Sorry about that. Sorry, folks, I'm having a technical difficulty. I'm going to ad-lib from here. The third panelist is Antoine Cottrell. He's an associate at Masfetch and Gordon, and his practice areas include real estate and probate, and he has been involved in applications for modification of restrictive covenants before the courts. And Anton and I work together on many similar projects. So the panel is here and comprised. I think we have a chat feature. You can also raise your hand and then be identified, and you can introduce yourself, indicate what your question is, hope it's a question or a comment. If you wish, you can indicate which member of the panel you would like to provide a response. So I'm going to open the floor. I'm just checking to see if we have any comments to start off with. And I'm going to start, just to get the ball rolling, I'm going to start with Earl Spencer. He says, re-affected neighbors, some people think it is limited to adjoining holdings when it really applies to the full subdivision that share the same covenants on each title. What happens when several new subdivisions come out of the original subdivision? When are the covenants modified to allow for the smaller subdivisions? So Alton, I'm going to ask you to consider Earl's question, which is really, I suppose, nested subdivisions arising from a previous subdivision, the covenants.
Subsequent subdivision. Yes.
Correct.
I'm going to share an interesting concept with you. I was taught by a now deceased, very expert conveyancer that in the development of land, you encounter gender. Yes, gender. That land in and of itself is feminine because it can produce from itself a series of offspring. But that strata properties are masculine because they can't reproduce anything from themselves. I was amused by the analogy at the time, which was about 40 years ago, but I found it to be an excellent analogy. So what happens with land is that whenever it is, any part of it is further subdivided, it is regarded as genealogically traceable, but still separate. It's like a parent having a child. and that child then has its own DNA string, so to speak. So the further subdivision will have its own set of covenants. And typically, it's only the covenants in gross, those which are imposed for the benefit of the public, you know, not to discharge water onto the road, etc. Those covenants would still apply regardless, but you then have a special set of individual covenants that govern the new subdivision evolved from the older one. That's my understanding of it. But I think Rose can help us with that also.
No, I think you've covered it beautifully. My thoughts on what you've just said are very layman. I'm thinking about the parent analogy, the mother, father, because my brain immediately went to, but it could be either, because the father is as much the parent as the mother, but I will leave that one alone for another discussion, Alton.
Thanks, Alton and Rose. I'm going to ask if anybody from our audience has a question they would like to ask the panel. Raise your hand. If not, I'm going to go back to the Q&A.
I see Jermaine Johnson have the hand up, Krishna.
Okay, you're seeing more than me, Sir Dayton. Jermaine, you would like to, I think you may be able to unmute yourself. Someone might have to assist Jermaine, and to maybe identify yourself and where you're coming from and what your question is. And if you'd like to, you could say who you'd like to have a response from. Jermaine?
He's muted.
Also, I have Michelle Jones Francis.
All right, Michelle, are you able to unmute yourself?
Yes, I did.
You need to be unmuted.
I did.
Okay, go ahead, Michelle, please. Thank you.
Good morning. It's a pleasure to be here. Thank you all for the presentations thus far. I have one question. If I have a piece of land, right, with a title that says no building of any kind other than a private dwelling house, and I am contemplating a multi-family dwelling, but not for sale, but for rental, would a restrictive covenant be required?
Simple answer is yes.
Okay.
Once you're going to be something that is different from what is set out on the title, the covenants on the title, irrespective of whether you intend to sell or rent, that particular covenant would have to be modified, yes.
Okay, thank you.
And I would add to that. If you don't modify the covenant, and by some miracle or mistake of the registrar of titles, you actually get the development approved and you get a strata plan. There are circumstances where the registrar can lodge a registrar's caveat against the land and against the splinter titles, preventing you from dealing with those units in the development. And so you are essentially, even though you didn't modify the covenant in the first place, you still will be required at a later date to modify.
And I would add to that, that what is not said, but said in the question is that the development when complete, none of the units are going to be sold. So there is a possibility that it would never get to the registrar of titles if you do not intend to obtain titles for the units as splintered. If the title is entirely going to remain in your name, you never have to engage with the registrar.
Can I make an interesting comment? The statute was changed 2 years ago. Section 126 of the Registration of Titles Act, which speaks to subdivision. They removed the qualifier of the land being divided for purposes of sale. So the section now reads, once the land is divided. And if we look back at the Local Improvements Act, it does stipulate that the building of more than one unit on the property constitutes subdivision. So the person may end up in a situation where a surveyor comes to inspect the property and provides an ID report which says that it has been subdivided in breach of the Local Improvements Act and Registration of Titles Act.
But if it has continuous walls, I mean, it's something that I've thought of though, Alton. If it's you know, I don't see you know how, because you know that in the good old days, what used to happen is that because two buildings are deemed to be a subdivision, often persons try to get around it by joining them together.
The duplex.
So it does thing there. But the other thing that perplexes in my mind now really is the multi-story, because although, and I'm glad you mentioned that case in the Golden Triangle, that they didn't get any subdivision, but they could possibly get strata titles. It seems to me that the going up several heights, we have not really captured that are limited that. I mean, except in specific cases where, you know, not more like in the grill, not more than 2 coconut tree heights or something like that. You know.
I think also that you have to look at the actual wording of the covenant, because the wording that was stated is no more than a private dwelling. So once there's going to be more than one private dwelling, then it is going to be in breach of the covenant too. So a lot depends on the wording of the covenant and then how it applies to the particular situation that's being implemented.
You see, well, the thing is that, and I'm glad for that intervention, Lycia. Is Lycia or Lycia? How is it pronounced?
It's Lycia.
Lycia.
Yeah.
Lycia.
Like
Yeah.
Keisha,
Yes,
but-
Lycia. You know, it just when the guy builds the Taj Mahal or what have you, you know, it's something that you know, it's sometimes difficult to differentiate a single dwelling once it encompasses all the surrounding walls and gives the appearance from the outside to the one.
Yeah. So there might be different rooms within the structure, but because they have internal communication, they're deemed to be one dwelling house. But
indeed,
in reality, you could have several different families living in the dwelling houses within the one structure.
Krishna, you have Nicholas Weller.
Nicholas Weller. All right, Nicholas, you want to unmute and introduce yourself and ask the question?
Hi, good morning. Can you hear me?
Can hear you loud and clear.
Wonderful. All right. My name is Nicholas Weller. I'm a commissioned land surveyor. The question that I have, and it's really coming from a trend that I have noticed. For developers, we notice that there are a number of multifamily development taking place. Take, for example, in the Havendale area, right? And looking at the initial titles that were provided for those lots, we see where we have covenants such as there shall be no subdivision of the said land, no building of any kind other than a private dwelling house shall be permitted onto it, right? With those two covenants, considering those two covenants, we know, look at what a developer would do. The developer would want to get those two covenants modified, right? And having modified those covenants, we see, for example, what I'm looking at here on a strata plan, a restrictive covenant that was modified. So we have a number 1 covenant saying that there shall be no further subdivision of the said land, save and except to erect a multifamily residential housing apartment consisting of 9 studio units. Yeah, the question that I have is, when a modification like that is done and it states exactly what should be on ground, when a surveyor goes on ground and they see 9 two-bedroom units, solid concrete wall right through and through, how does one go about modifying that covenant again?
I think the conversation then should be about demolition, but that's just me.
Yes, because it's likely you got.
Because what that suggests is that the developer applied for or intended only to obtain approval for 9 studio units. Having gotten that approval, the developer then decides that it's going to do something else. And the trend there, I wouldn't say trend, and for certain developers, they having made that decision, they act on it. And then they go to brilliant attorneys like Alton John and say, how can I fix this so that I can get through the back gate and get approval after the fact for something that is in breach of every piece of law you can find, and hope that it will be allowed to stand. So my starting position is that we should not consider demolition, because chances are that this 9 studio was permitted because that was all that could have been permitted in the first instance.
Right, and these are small lots under 1/4 acre, more or less.
The associated with density is not just the size of the rooms, it's everything else. It's amenity space, it's traffic, you think of it. Those are the problems that will now flow to what, 9 times 2 is what, 18? To 18 rooms versus 9.
But giving regard to the Belgravia decision for Rosemary Drive, how could he ever have gotten a valid approval for a 1/4 acre lot to be developed?
That is Alton, your question is spot on, because
Wrong.
I
do not agree.
I thought you needed a 1/2 acre for
No,
any
you
multi-development.
You're speaking about a provisional development order that is really a document that is not yet law. And so the planning authorities have the jurisdiction to look at, which I'm not necessarily talking about that particular location alone, but, and it's not that this is a pet peeve of mine for those who are saying, oh, there she goes again. It's that the authority can look at several other planning parameters, indicators to determine whether, even though it is on a 1/3 acre, a multifamily can be permitted. No, a multifamily being permitted, you now have to look at how many rooms. But the first question is, can it be permitted for multifamily versus single family? And then the next.
Can permit it.
Yes.
The local planning authority versus the town and country planning authority.
That's where you are.
Yeah, because to derogate from the minimum standards, even in a provisional development order, I think it would have to be more than the local planning authority.
Absolutely not. The Privy Council has ruled that this is an incorrect statement of law, what you just said, in my humble view.
Okay.
But I will stop on that point.
But what I would say is that I think it brings to the fore that it needs to be looked at holistically, and that's a part of the problem. Each agency is looking at their small aspect instead of looking at the problem in its entirety, because we do need orderly development and we need to find the proper way in which to do it. So all of the relevant agencies need to look at what their obligations are, what the aims of the various legislations are, and then how they can all be implemented and have the development proceed in the way that it should.
I'm going to, it's a very, very important point you have raised. And I remember, you people may recall the advent of this, I call it the Spanish Armada, when the Spanish came in and they were building hotels, and had the benefit of a lunch speaking engagement by Jesus, I think the Silva, he was the ambassador from Spain. And the guidelines he was laying down is that he said, like in Spain, specific areas, it stated clearly what you can do and not do. And I believe that we that is perhaps, Rose, as you're going to guide the ministers, I really think that there needs to be clarity on that particular point. It is, I don't think it's fair to be asking the authorities to decide half acre, 1 acre, I mean, quarter acre, this. I really think that it needs to be clear.
That's what obtains
into that area.
Isn't that what obtains all over the world? It's the planning authorities that have the expert or ought to have the expert personnel in-house to guide certain decisions. Note I said ought to.
No, thank you.
And so when it comes to court, you shouldn't be asking a judge to go take out a measuring rod to see, is this, what is the extent and nature, the nuanced nature of certain types of physical breaches. And in fact, curiously enough, in several parts of the world, including England, it's not even really the courts that make certain decisions on applications for restrictive covenants, discharge, or modification. It is technical teams, including the architects and the engineers and so on, who can give a certain kind of informed decisions when applications are made, and then it's where they breach the rules of how they're supposed to arrive at decisions, that it is bounced to the court.
Yeah, very good point there.
Yes, it's something that we should perhaps, that this body could perhaps consider, look at what obtains elsewhere and see whether time comes for you all, you experts, to know, say to government that it should be us who should be part of the decision-making process when you're going to make certain changes to, or when applications are made for modification or discharge. It comes to the technical persons, not government bodies per se, but from the private sector, where persons can be selected, persons of the highest standards, to arrive at decisions, and where the decisions are arrived at outside of the four corners of of the rules, then you seek judicial review of the decision-making process. In fact, recently, a court that went to the Supreme Court in England, the equivalent of the House of Lords, it was the first time in the history of that country that they were making certain kinds of decisions on the interpretation of the Restrictive Covenants Act. First time. So, we're asking non-experts and non-technical experts to make certain kinds of technical decisions, and you now should be lobbying for it to be placed in your hands. And I think it may assist with some of the problems that we're having, some of the decisions that persons who have an understanding of planning law are a little concerned that the decisions, if they bounce to England, will not stand.
It comes back to this issue of job descriptions, because I recall there was a time when the city engineer was not an engineer. And I don't know that there is a strict requirement for the person holding that post to be a qualified and registered engineer with the Institute of Engineers. It's issues like that which need to be cleared up, quite frankly, and we're seeing the fallout from approvals of developments up in the Tavistock, Jacksonville area, which raises the question of who did the technical evaluation to sign off on those approvals.
Just to ask a question. The provisional development order for Kingston and St. Andrew, was not approved recently?
It is, it was. It's now a confirmed development order.
Okay.
6 years later.
And for some areas, densities have decreased, for some it's increased. So when we all get a chance to drill down into it, we will have some happiness and some unhappiness with those bits that have changed.
And that in combination with the new Building Act, I think should, if these things are properly enforced, and I think we should resolve a number of the problems. Now, to get back to what you were saying, Rose, about having a technical committee. Some time ago, we had recommended that the NEPA has this wonderful developers assistant committee. And one of the recommendations was that this committee would look at an outline plan, have legal representation looking at the documents. The developer would have a lawyer, as Alton was pointing out, say what modification of covenants will be required. And the committee would then pass it on to a committee that would just do just what you're saying. Look at all the thing in its entirety and then make a recommendation to the Master and Chambers as to whether or not the covenant should be modified. And this committee would include the councillors for the area that would have the neighbors. So the neighbors and the neighborhood would get involved in having a say in this whole matter. And before the developer got in too far down the road, spending a lot of money, he would have get an answer in fairly short order. Anyhow, let us hope that we are moving in the right direction. And I think Minister Chuck earlier on this morning really came out strongly in favor of something like that. So hopefully we can get some movements now.
That was a very stimulating question. And I think implicit in the presentation on involving other professionals in considering the viability of any application. So, your realtor, surveyor, etc. I think implicit in what the presenters were saying is before you even buy the asset or choose to buy the asset, you need to think about doing your due diligence and going to, including, as Dayton mentioned, methods, DAC, to see what problems you could have.
Krishna, I see Mr. Peter Matalan has his hand up.
Apply.
Oh.
Peter, you want to
morning,
unmute
morning,
and
everyone.
ask
Morning,
your question?
everyone. Just to touch on what Rose had said a while ago, we have been purporting, the developers have been purporting, including the Developers Association, to establish a single entity governed mostly by professionals in the industry to facilitate the development, the development approval and process. It's something we've been pushing for such a long time because, as you rightly say, there are a lot of these agencies who, you end up going around and around and never ever, you're not utilizing the technical expertise of the professionals within the industry. And if we do that, we'd solve a lot of the problems that we currently have now.
Yes.
I don't know what it would take to do that. I mean, it's been going on for some time.
Some of it, Sir Peter, may require legislative change.
Yeah.
Some of it, and some lobbying. I mean, and some things are lower hanging fruit than others. I mean, even the planning application and approval process, and the fact that several years ago, I know that the attorneys here will recall, several years ago, if you submitted an application for approval and the decision was no, or you didn't like the conditions attached to the decision, you could appeal to a planning tribunal. There was a change. I think Sir Easton Douglas was a minister at the time, but he was a planner, so it made sense with him.
Yeah.
There was an amendment to allow for the appeals to then go to the minister. When the minister is not a planner and the appeal goes to the minister, who may have a different perspective on how these planning issues should be reviewed, then the outcome of the appeal may not be one that satisfies people in the industry, just from what is right and wrong from an industry standard perspective. What obtained before, to my own mind, was a better model where the appeal tribunal included technical experts. You have a senior attorney, you have an engineer, you have an architect, you have a planner, you have persons on the panel who are considering the appeal where a planning, an application for planning permission has been approved with conditions or been refused. The appeal should go to persons who understand the technical aspects of the appeal, not just the minister. Granted, I know that the minister, they have different ways in which they deal with that. But I think from your group, the developers can lobby for that amendment to, you know, that I think is a lower hanging fruit than some others. And the Building Act, there are certain bodies that have not yet been established.
Right.
Under the Building Act. Again, you can lobby to ensure that when these bodies are established, they include you, the professionals.
Well, that panel, in my opinion, should sign off on all multifamily developments. I mean, it would solve so many problems.
And make sure that Alton is on it.
I second that.
Let's just point it out that surveyors, we're leaving them out. They are, you know, but
absolutely.
I think the most important point that could come out from what Rose is saying is that these people have the benefit of experience, you know, and I agree with you, Rose, to ask a minister, I don't care how talented he is, to make such a decision is a bit unfair to the developer and even to the society as a whole, because what you want is a consistent approach when it comes to development. And Earl pointed out the surveyors, the architects, you know, the qualified people need to be there, because, you know, you look, people, let's look at what happened sometime in Mexico or Haiti or so on. I mean, right now, I don't know about you, but sometimes I wonder when I see 7, 8 stories going up, you know, are the necessary checks being made? Are they being done in such a way? Because, you know, these things come back to haunt you 10, 20, 30 years down the road. You know, so we need to bring this to the forefront of our legislatures, that we need to get this right. I don't know about you, Alton, but I mean, I remember when we were building right now I'm at 48 Duke Street, piles and piles went into this building, maybe because we're so near to the sea. I mean, to me, I see multi-story buildings going up like mushrooms over the place. And I'm wondering, you know, what sort of foundation being laid for those? But
and I think
go ahead, Lisha.
Sorry, I was just going to say, I think that's why it's so important that, as Rose said, that we have the technical persons within the regulatory bodies as well, because they have to know what it is that is being proposed to see whether or not it should be approved. If they fall down, then that's where you have the other processes coming in, but it starts with them. They have to do their regulation, they have to do their enforcement, and they have to supervise. If they don't supervise, by the time the building is up, it's already too late, because the damage that will occur when it comes down or something else is too much. So that's where it has to start from. And that is the basis on which the relevant agencies need to be saying to, whether it is Parliament or government, whoever, that these are the resources we need to be able to carry out these functions effectively and properly. After that, once they have the resources, if it is they're not doing what they're supposed to do, then other aspects come in to ensure that they begin to do what they're supposed to do. That's how it has to start.
Well, Rose and John, you may recall, I think it was about 40 years ago, where the Minister of Planning and Development, aka the Prime Minister, issued an edict calling in all applications of a certain nature away from the local planning authorities and directly into the Town and Country Planning Department. He essentially suspended their authority to give approvals and required that those things go directly to the Town and Country Planning Department.
Was that at the same time when the jurisdiction of all local authorities was suspended?
Yes, that's correct. Yeah. And but what has happened, however, is that there's an application threshold where certain applications below a certain volume are dealt with internally at the local planning agency, and then those of a higher volume go further up the chain. And what we see happening is that the low volume applications are sent in approved, and then an amendment is requested.
Absolutely.
The amendment is not being referred further up for higher approval, which is where the technical expertise resides. I'm of the view that there's no authority to amend, because there's a case I was involved in, merciful, 1999 decision by the Court of Appeal, Palmer versus Golden, where they made it very, very clear that once the approval had been given and signed off by the minister, the authority could
becomes
not
legislative.
change. Yes,
Except
could
though,
not change that
wasn't
approval
that,
at all.
I wonder though, wasn't that the Palmer Golden decision, which you know I addressed in the Riverage case that the court, wasn't that in respect to subdivisions, which is a little different from building approvals and planning permission, because a building approval under the Building Act can be amended. You can
Yes, I'm speaking to subdivisions.
So the subdivisions, okay, got
land and restrictive covenants. Yes, that's what I'm
Once
speaking.
approved, you're right. Once approved, you're locked in.
Yes.
The next question is whether you're equally locked in for stratas, and I think you're the better person to answer that one.
Well, I am of the view that you are, because the plan is what exempts, the approval of the plan is what exempts the yes, from the restrictive covenant and the local planning authorities, town and country planning, local improvements applications. So it becomes a question of, is this the strata plan? Yes, it is. That's the end of the story. If you want to amend it.
And without destruction.
Exactly. Right. Or you have to get an order of the court, which is one method I've used, where you can show that there was a genuine error which was made in the preparation of the strata plan, and the court makes an order declaring that, okay, a plan which corrects the error can be substituted.
Can I ask a question though? Because what I've seen in a lot of cases, what is approved, they go through all the required approval steps, but what is being built is not in accordance with the approval, and there is no recourse or no action taken at the end.
I think that this is where, because we don't have sufficient, or the municipalities are not rigorous in inspecting as they go along, that the architects or the engineers for that particular development should be the ones that sign off step by step that it is following the plan. If it's not following the plan, then they should so state. If they say to the otherwise, then there should be a bond that they have to post, which can then be called on for it to rectify any problems in the future. But we have to come back, we have professionals, architects, engineers, surveyors, quantity surveyors, who are intimate with each of these developments. And they should be the ones that have to sign an affidavit that it follows the planning approval, or it veers in somewhere or the other, which may be significant or may not be. It may be significant in one way, but not detrimental to the overall development. But that would require corrections or amendments.
I like that. That's brilliant. Sir, Earl, the bottom line is that we're looking at a failure to monitor and enforce by the regulatory, by the authorities who have a duty, who are required to do so. I don't want to use the word duty, because it has a different meaning. And when that happens, then the banks suffer. The pre-purchase or persons who have entered into contracts prior to completion of development suffers. The fallout is great. I do like what you said, Sir Dayton, about the architects, the professionals involved in the process for these developments stepping up and sharing the responsibility. Remember, I said earlier that there are the new Building Act, there are certain things that are not yet settled. Should I think of this as a takeaway, that kind of responsibility that the architects and some of the professionals in the process, the surveyors and so on, that they would want to have that kind of responsibility imposed on them in law? Or should it just be an understanding? Because remember, right now, the Building Act requires that the authorities sign off at each stage of the development. It's a legal requirement.
Well,
They're failing
I would think that this would be a question for the engineers and the JIE and the Jamaica Institute of Architects and the surveyors to opine on. But from a developer's point of view, I would think that this would be, and certainly Developers Association, we have a code of conduct. We expect our members to abide by the regulations. And this would be a good way to bring everybody on board. That's my view.
Yeah, I think the professional association should hold their members accountable. I have to engage professionals to inspect and supervise the reports or review the reports that I'm getting from their colleagues. I mean, I would consider it an embarrassment.
Well, I can issue a cautionary word. The Court of Appeal decided some years ago, case of McNaughton versus Dumais and others. And they followed an earlier decision from back in the 70s, that where you have professionals involved, the duty of care was that of the professional at a much higher standard.
The word duty, yes.
Yes, and they can be held accountable if defects are discovered much later. And what the Court of Appeal said is that defects period was of no consequence, which was a contractual arrangement between the developer and the purchaser. The professionals would remain liable until the defect was discovered. And once the defect was discovered, the limitation period was going to be 6 years. So the defect could turn up 10 years' time, and 16 years later, the professional finds that they're being held to account for failure to supervise the implementation of the plan if they were on site and providing post-contract, post-design services.
Very good. I think Stokely Marshall, Krishna, and then I think we're running short on time here.
Well, I'll be very quick. Thank you very much, sir. And Stokely Marshall, attorney at law. I'll be very quick. In light of what is being raised about architects and engineers, a question here. Can an engineer sign a completion certificate, which I typically see referred to as a certificate of practical completion? And this would be in relation to a new residential development. And I tell you what, I ask because it is usually done, in my experience, by an architect, or I've seen it also by a quantity surveyor, I think, a quantity surveyor, but usually by an architect. But what if the engineer is the lead on the project and that person signs the certificate? And I ask because sometimes I'm asked to represent purchasers in new developments, and this is something that I've seen happen or occur. Another thing I want to ask is, what if someone is not a registered architect, but they're employed by the developer to produce the architectural drawings, and that professional who produces these architectural drawings, it might turn out, is actually employed to, and this might be a little bit political here, not party politics, the person might be employed to the municipal corporation or to one of the municipal corporations, but they are not really registered architects, if they could be responded to in that sequence. First on the practical completion certificates, and then in terms of the person who produces the drawings not being a registered architect. It's a question that a purchaser could have concerns about.
Krishna, I think that's an excellent segue into our next presentation.
Our second panel, correct. Yes, Stokely. So we have a panel on the role of architects, and I think we can have those questions, or they can address your questions which are relevant in that panel. I think what I would say as moderator is that in the last 5 or 10 years, we have seen a lot of litigation, which I think would have started with judicial review of the decision makers' decisions, which has evolved a bit to include litigation against developers, the persons making the new development, investors, etc. And it might be a real question as to whether, as the regulator for lawyers gets involved with complaints about attorneys' conduct, whether similar professional bodies were established by statute, for example, land surveyors, architects, etc., are then that mechanism of disciplinary proceedings in each professional body becomes an avenue for concerned citizens or other persons to seek some sort of redress, explanation, or seek to create some sort of regulatory feedback loop on the professionals, because this situation is very topical and it is evolving. And I do think that concerned citizens and alert attorneys can use any avenue to try and protect their clients' interests. So I think we may see it where you have these complaints being pursued to the relevant disciplinary bodies. I hear the chairman saying I'm coming up to the end of this panel.
No, I was wrong.
So I'm going to thank the...
You still have a few minutes, Krishna.
A few minutes, okay, because I think I have about six or 7 minutes.
Yeah, man. My bad.
No problem. Rose, I'm going to ask you to take a simple question, and the answer might not be a very pleasant one. But there is a question from an anonymous person in the Q&A, and he or she asks whether the recently approved, the confirmed development order, which is a list of modifications to the provisional development order, will be reduced to one comprehensive document. So I wonder if you could just explain to the audience how you have one comprehensive document. So I wonder if you could just explain to the audience about the confirmation notice and the amendments which are listed in there, and how perhaps a professional or a layperson could read those two documents.
Okay, so I have not looked at the confirmation notice. I've looked at several in the past. I've not looked at the one for Kingston and St. Andrew and the Pedro Keys. I would caution that when you're reading the actual amended development order, I'm looking to see if I can find, just give me 1 second here. I am still here, but I am standing. Okay, so I would caution that when you are looking at the confirmed development order for Kingston and St. Andrew and the Pedro Keys, that you do so with a lawyer nearby. This is what the provisional document looked like. See, all of these tabs, you can just, I spent a whole heap of time in court, either prosecuting people who did the wrong thing or defending the government when citizens sue them. Yes? The confirmed development order remains this document, which you would now have to read along with the confirmation notice, and the confirmation notice would have in it those parts of the order, would make reference to those parts of the provisional order that have been thrown out or amended. At some point, it is expected that the document would, the relevant body or government would make the document one comprehensive document, so that the amendments would now be incorporated in the provisional, so that you will have a document that is now called the confirmed development order. And it would include all the new bits, which replaces the old bits. Does that answer?
Yes, Rose, I think the answer you've given us is no one comprehensive document right now.
Not at the moment, not at the moment.
And it's very difficult to read unless you have the right professional eyes.
And the reason why I'm working, as you would know, that even with amendments to any form of legislation, you're going to start out with the notice. Alton, help me with the right, you senior citizen moment, with that document which identifies what are the amendments to the legislation. And then at some point down the line, you're going to have the legislation which now will include the proposed amendment. But you don't start with it, you start with separate pieces of the law. Correct, Sir John?
Correct. Yeah.
All right.
There's another question in the chat, and I'm going to ask Antoine to comment on it. And it says, it's from Loy Murray. It says, I think the lenders could also take a more active role before they lend the mortgages by sending out their own experts to verify, as a lot of mortgages are granted to development, including new ones where breaches exist. Then it gets very messy. I just ask Antoine and any of the panelists to comment whether they've seen any change in the behavior of the banks, given all the litigation that we have seen recently.
Yes, we see where banks are now actually getting legal opinions from attorneys on the modification of restrictive covenants. We see banks trying to now look at whether planning permit or permission is actually safe, or whether it can be, subject to judicial review, which is a very new thing, I would say. We also, as the gentleman mentioned before, we also see banks hiring their own professionals to check whether a development is being constructed in accordance with the permit. And another thing we might see in the future is that banks will start to put in their term sheets and in their loan documents requirements that the developers actually provide information or provide professional information as to their compliance with the planning permission, which is a new thing. But because of the decisions of the court and the risk of demolition orders, stop orders, banks need to ensure that the loans that they give are secure. And so it's very interesting how the recent decisions have impacted the sector, and I think it's with good reason, because we want to ensure that developments are constructed properly, so that citizens are not shortchanged when they buy a unit in a new development.
I don't know if anybody wants to add to that before
I'll just add to that.
Sure, John.
As a banker, to say that we ensure compliance at the application stage, and we also monitor the projects by engaging professionals to monitor and provide us with timely updates.
Thanks, John. Earl, were you trying to say something? I think your microphone is open on that point. No?
No, I was just agreeing with, is it Antoine? To say that as a banker, we ensure that all applications comply with all the statutory requirements. And during the construction phase, we also engage professionals to monitor the projects on our behalf.
Wonderful. And so, Earl, I think Antoine is actually saying that what we see now is not merely a checking off whether you have your environmental permit, environmental license, planning approval, building approval. Someone will actually look at it and see whether that approval, whether it was lawfully granted by the regulatory authority, and therefore you're safe from a judicial review action, which is a new kind of heightened awareness by some of the banks. Not a checklist, but is the approval actually defendable?
I agree. And you pay more, there's greater scrutiny where it is someone who is not a seasoned or regular developer.
Yes. If I may, the only thing I would add to that is that we bear in mind that the judicial review is never going to be of the developer, as all the attorneys would be aware, it's never going to be of what the developer did or failed to do, or what the banks did or failed to do. It will always be a review of what the authorities who have certain duties under law, what they failed to do. So what the banks would be looking at is whether the approvals obtained would stand up to scrutiny if someone goes to court and say that the planning authority, whether it is the central planning authority, NEPA, or the local, which is the municipal authority, whether they did anything wrong or whether they gave approval that was contrary to any of the laws under which they operate. So the judicial review will always be of the government body's approvals. And I don't know how far the banks would be prepared to go in building out their team. Are they going to, would they now be having to think that I have to include lawyers, call Antoine and say, Antoine, I don't have these applications, or these persons have come to the bank. They want money to build a multi-billion-dollar development. And I see they have approval. Antoine, you tell me whether this approval is a good one. Did the council make a decision? Did NEPA make a wrong decision? I mean, is that where the banks will now have to go? I don't know.
I'm not sure, but what we do see is approval from NEPA and from a municipal authority. We have seen inconsistency in the reference project.
And the truth is that we should be able to rely on them, shouldn't we?
Absolutely, but we do our detailed checks.
Rose, a question from that is, if a developer relies on the planning authority to issue a proper permit, and then some years down the road, there's a demolition order against him, does the developer then say or have a claim against the planning authority, and will he actually proceed against the planning authority?
That's a terrifying question.
Terrifying.
I represent most of the planning authorities, so it's a wicked question. However, the truth is that the law does allow, the Town and Country Planning Act does allow the authority to withdraw the approval grant.
Exactly.
There are certain things that will follow. And similarly, the development approval, as you all know, has several layers. You have the planning permission, the building approval, the environmental permit, and so on and so forth. So they can reverse course later on if they realize that based on current circumstances, we now need to say to you, the developer, you need to knock this down. But if they have, dependent on the reason why they're asking, where we have issued a demolition order, it could be that you failed to provide all relevant information when you submitted the application. So they gave you approval for a 6-story building because you failed to advise them that there were certain problems with the land on which this building is to be constructed. So they would be able to flip that on you and say that it was your fault. It was your failure that has ultimately led to the demolition order.
Mr. Chairman, I just want to warn all of us that we have the benefit of the torrent system. And the torrent system says what you see is what you get. So we have to be very, very careful how we go outside of that, because it has implications for our banks and everybody, developers, and so on and so forth. We need, otherwise, we're going to have to go into the American system of property insurance, and that is an area or a can of worms that I don't know if we really want to get into. So all our professionals involved, we're aware of the fact that we need certainty. That is what has enabled us to operate the system that we presently have. Those are my 2 cents.
Well, John, on that score, I was involved in title insurance that was introduced to Jamaica about 15 years ago. And it was felt at the time that it was superfluous. And then came the decision from the Privy Council in the Lazarus and Recreational Holdings, which said your title could be subject to adverse possession. So maybe we need to revisit title insurance again.
I think so.
Please note that Sir Earl is here, the bankers, they will just put up all kinds of costs on us if we don't be imposing.
What I'm gathering from this discussion is whether we ought not to engage all the regulatory authorities in a special discussion so we can have a better understanding, because I see there are a lot of inconsistency, and I don't know whether they understand the impact or the cost of failure to carry out their duties as prescribed.
Perhaps we should invite Minister Chuck to call a Come to Jesus meeting. Or have these things discussed at length So that the banks, because I mean, what you're talking about earlier is increasing the cost to developers, homeowners, your mortgagees, mortgagors rather. And you know, that's just going, that's not good. So and it's all because we, you know, we swallowed a fly and you swallowed a this and you swallowed a that to get the fly and, you know, down the road. And it's totally unnecessary. But we have to deal with the monster.
I think one of the challenges, Dayton, is that developers are not regulated as a body.
Well, the municipalities and the NEPA and those people are the regulators for developers.
Real estate board.
Those are our partners in development.
And the Real Estate Dealers and Developers Act give a certain amount of regulatory authority over developers, limited though, because the development is regulated by the municipal authorities and NEPA and so on, but the developers are regulated in a limited way by Real Estate Board.
Yes.
Am I understanding perhaps that the thinking is that the nature and extent of the regulation of the developers should be expanded? Because right now we're in the process of amending that legislation. It is far advanced. And there is going to be heightened scrutiny and responsibility and regulation placed on developers. That amended legislation is around the corner. I will look again on it to see to what extent and how far it imposes some of what we've discussed today, some of the additional regulatory requirements.
It will be useful. It will be useful, Ms. Rose, if you could share that with Alton and some of the legal luminaries on this panel.
And I know Caroline, yes, who is part of the committee that is dealing with that proposed amended legislation as part of this body.
Right.
But we can speak.
Mr. Chairman and all, I don't want to end this very stimulating conversation, but we're trespassing, adversely possessing the next panelist's time. So really my job is to say that clearly the dilemma continues. I think we will, on behalf of the chairman of the JDA, that Earl's suggestion about a conversation with regulators to better improve the process and not make it worse is due or overdue. So that's something we can take from this interaction. And I want to thank again the presenters and the panelists. We're going to have a short commercial break again, and then we're going to move into the second panel, which is, as I indicated, the role of one of the other professionals, the architects, and issuing of completion certificates. So a short break, and then we'll move on. John, you want to say something?
No, sir.
Okay.
Thank you, everyone.
Thank you.
Thank you, Alton. Wonderful. And Lucian.
Capture all the sweet moments in your own sweet home. Up to 100% financing from JN Bank will get you there. Get pre-approved now. JN Bank will help you find a way.
For almost 40 years, the JDA Group of companies have been developing plans, laying foundations, building hundreds of homes of distinction, creating exclusive and secure communities in which we live, play, and raise families. The JDA Group of companies, creating homes that people enjoy.
The Guaranteed Purchase Program is an initiative of the NHT to bring more houses faster to contributors. Under this agreement, the NHT will purchase housing solutions from developers for resale to its contributors. The GPP offers win-win solutions for everyone: the developers, the NHT, and most importantly, the contributors.
DigiView Security Limited. Operating for almost 15 years, DigiView Security Limited is one of Jamaica's premier electronic security solutions providers. DigiView offers top-of-the-line solutions and services to protect your home and business in the ever-evolving electronic security industry. AI features: perimeter protection camera, human detection and line cross, license plate recognition, panoramic 180-degree camera, 360-degree camera, face recognition, intelligent search and playback functions. DigiView Security Limited. See what you've been missing.
Of our panelists for this panel. So our first panelist is Mr. Robert Fowler, architect, Bob Fowler and Associates. Bob graduated from McGill University in 1977. He began his professional journey at the Ministry of Works Architects branch, where he served as a senior executive architect for nearly 2 years. However, he decided to step down from his position to pursue a contract as a project architect for the UE, which spanned the following 2 years. After concluding his contract with UE, Bob established his own architectural firm, Bob Fowler Associates, in January 1981. Under his leadership, the firm has consistently operated successfully and gained a strong reputation. Some notable projects completed by the firm include the Grace Kennedy corporate headquarters on Harbor Street, the regional headquarters for UE, which is opposite the entrance gates to Mona campus, all the KFC restaurants throughout Jamaica, and the total logistics facility for Kingston Wharves. Our other presenter, Bob, I think you are our only presenter for this panel. I'm going to invite you to bring up your presentation and to begin on the role of architects and the issuing of completion certificates.
Okay, good morning.
I'll turn over to you.
Morning, everyone. No pretty slides, and because it's a technical subject, which I may have to read a bit while I'm going through it. What I'd like to start with is not a definition of practical completion, but telling you what practical completion is not, because it's a term which is often mistaken to be the point at which a construction contract has been completed. In actuality, it defines a point in time when a contract passes from a stage of active construction to a period of maintenance or defects liability on the part of the contractor. But this is not to say that construction work does not continue beyond practical completion. Unfortunately, it can, and I submit it almost always does, but to a far limited extent. Now, practical completion is a term that we have inherited as part of our colonial heritage from the Royal Institute of British Architects. And that is what is used in the standard form of contract prepared by the Construction Industry Council of Jamaica to define stage in that contract. Elsewhere, it may be known as substantial completion. That's a term used in the FIDIC, F-I-D-I-C, which is the International Federation of Consulting Engineers form of contract, and also in the American Institute of Architects, AIA form of contract. Now, a point to be noted, this is very important, is the fact that both practical and substantial are not absolutes and are therefore subject to interpretation by the architect, supervising officer, or contract administrator as designated in a particular form of contract used. Now, the question was asked earlier by, I think it might have been Stokely Marshall, can an engineer sign the certificate of completion? Yes, absolutely. It depends on who is designated in the contract as in this case, the engineer would not be designated architect, but probably supervising officer or contract administrator. But clearly, the person who issues the certificate has to be designated in the contract. And as for the question of a non-registered architect, well, that one rubs me very, very hard as a member of the Architects Registration Board, because they have no business doing practice in architecture at this level. Now, in an ideal world, construction would cease on or before the date in the appendix of a construction contract as a date of completion. But invariably, things happen, and a contractor may be forced to claim an extension of time for one reason or another before the date of completion is reached. If, in the opinion of the architect, supervising officer, or contract administrator, the reasons claimed are contractually valid, then an extension of time to the contract period, and by extension, the date of completion may be granted. This is fairly well known. Now, when the contractor is of the opinion that he has completed the work, he, she, they have completed the work under the contract, then he will call for an inspection and request a certificate of practical completion, or a taking over certificate. Taking over certificate is absolutely the same thing, but it's a term that's used in a FIDIC form of contract. And then this, of course, would be issued by the architect or supervising officer. You will note that, again, I refer to the architect or supervising officer, and this is because as the person named in the contract, they are the only ones who can issue this certification. A practical completion certificate cannot be issued by the owner for a number of good reasons, which I will elaborate on. And this is probably a good time to give you a definition that I use for practical completion. And that is the date of practical completion of the work or designated portion thereof is the date certified by the architect when, in his or her opinion, again, getting back to the subjectivity of this, the construction is sufficiently complete in accordance with the contract documents, so the owner may occupy the work or designated portion thereof for the use for which it is intended. Right, okay, so again, we have in his or her opinion and sufficiently complete, both very subjective and not absolute. Now, certifying of the date is obviously important for a number of reasons, because once practical completion is certified, the contractor becomes eligible for the partial release of retention monies, usually a half, which have been deducted from payment certificates up to an agreed limit stated in the appendix of the contract. So obviously they're anxious to get that money. And the date of practical completion marks the start of the defects liability period, which I will elaborate on more. And the date established also determines how much, if any, additional compensation there is due to the contractor, which he might be entitled to if no extension of time has been granted. He might be held liable for liquidated or ascertained damages as defined in the appendix of the contract. So you see, we're really talking about here a date, the establishment of a very important date. And this, of course, is also the point at which the owner or the client should take over the building and release the contractor from the requirements to maintain insurance on the property. Now, it may be that the client or owner is not in agreement with the architect or supervising officer that a project has attained practical completion for a number of reasons. Sometimes a client who is unfamiliar with the process of construction or of a construction contract may have the mistaken expectation that practical completion means that all defects of materials and or workmanship have been made good, and that no work should be left outstanding for completion. This is somewhat unrealistic, and extending the construction contract in this way could create undue hardship for the contractor. And I think the lawyers will agree that if certification is viewed to have been vexatiously withheld, it might be deemed a breach of the contract in litigation. On the other side of the coin, accepting a building with numerous defects or work remaining to be completed, even if observed and duly noted for the contractor's attention, can be a risky undertaking. This is why part of the definition of practical completion that states the owner may occupy the work or designated portion thereof for the use for which it is intended is a good measure when applied to an otherwise subjective definition. And I think earlier, or if not this morning on a sidebar, Earl Samuels was saying that he has had instances where practical completion has been certified, but the people cannot occupy the units for which they are seeking a mortgage. Now, clearly, that is not practical completion. A couple of little things that I insist on, not so little, when I'm doing an inspection. For instance, you have to be able to turn on the lights. You have to be able to see everything clearly. If it's an office building, you'd want to feel the cool breeze of the air conditioning, and on it goes. I mean, let me get back to the fine line that the architect must walk when issuing a certificate of practical completion. You must not be swayed by the undue influence of the contractor or the owner who pays you in making what has to be an impartial assessment. Now, in point of fact, certification for practical completion is a process. It's not it happens not all at one time. It begins once the contractor gives the architect notice that he or she will be, they will be ready for inspection on a particular date. This notice should be shared with all members of the construction team, as well as the client or owner, so that they may be in attendance. At the end of the inspection, and this can conceivably, this inspection may take days depending on the scope of work, the size of the project, the complexity of the project. The architect has to prepare a detailed list of defects and notes of work outstanding. Now, this should not be just something that the architect is judging on fit or finish or materials or workmanship, not in accordance with the contract, but also requires the input of the engineers, the electrical, mechanical, structural, civil, as well as the project's quantity surveyors, not land surveyors at this point. Anyway, this list, once it's completed, is appended to the certificate of practical completion. Now, I would tell you there are other things which need to be included at this point. For example, fire safety certificate. It has happened to me more than once on office developments where I am being pushed by project manager to sign off practical completion, but we don't have a fire safety certificate from the Jamaica Fire Brigade. No, I can't do that. Am I going to accept liability for occupancy for a building which maybe the sprinkler system is not yet completed or whatever else the fire department requires? Absolutely not. You know, that is an important part of practical completion. So you have to be thorough. And the properly worded certificate of practical completion will contain a signed undertaking from the contractor to make good all of these defects noted and complete all outstanding items of work in a specified time. Now, experience has told me that this generally means nothing, but we try. Time period is generally not as generous as a period of defects liability. We're not talking months. We should be talking days or weeks. But as I said, sometimes these things stretch out. Now, there is a form of contract, a form of certificate of practical completion that is published by the Jamaican Institute of Architects that I think is an excellent one, and one I've used personally for over 40 years, which beyond the signature of the architect certifying the date of practical completion, it's also must be signed by the contractor agreeing to complete or correct the work in the appended list in a specified time. And there's also a place for the owner to sign, agreeing on a date on which he or she will assume full possession. I would like to probably bring up this certificate, if you pardon my ineptitude on these technical matters here, but let me try and I don't know how I get back to share screen. 1 second. All right. Okay, I should be sharing screen now. Why it's not. Okay, let's make this a little larger. This is a JDA publication, and the usual prerequisites, the definition of the project, and it contains the definition for practical completion that I've just given, and also speaks to the list of defects. I hope maybe the screen could be a little larger. There we go. And duly signed by the architect, duly signed by the contractor. You'll note that above the signature of the contractor, he says the contractor will complete or correct the work on the list of items appended here to within, and then a number of days to be filled in from the date of practical completion. And continuing, it's also signed by the owner. And final note is that the responsibilities of the owner for maintenance, utilities, insurance, that is also described separately. Now, I'm going to return to my screen if you don't mind and not share. Not sure how I'm doing that. Anyway, okay. Oh, very good. All right. And it would be unreasonable to assume that all defects can be noted at the time of inspection. And it's precisely for this reason that all construction contracts call for a defects liability period, which is also known as the maintenance period. And during the defects liability period, which generally lasts 6 months, the architect and his or her fellow consultants and the contractor are essentially on call to the owner. The owner will doubtless find other defects to be made good before the final inspection, which is obviously at the end of the maintenance period. Before that is held, and would want to bring these to the attention of the architect and through him or her to have them rectified by the contractor. It is generally assumed that after the architect has had the use, after the owner has had the use of his or her building for 6 months, any defects that were not evident at the time of practical completion will have become noticeable and can be brought to the attention of the contractor, who can either make them good or have the cost of making them good by others quantified and deducted from the sums owed by the contractor in the final account, and or from the final portion of the retention money held. Now, this is important because sometimes the cost of making good a defect may be so onerous on the contractor that he will simply walk away from it. He'll say, well, the sum that is included in the bill of quantities for that item of work, when it comes to making it good, like for instance, ripping up a tile floor and retiling it if it wasn't properly done in the first place, he may just say, I'm going to walk away from that and you can get somebody else to do it. And this is where, this is why I personally like to work with a select group of contractors. And one of the reasons why, and I don't mean to offend anybody, but why I don't do government work, because I've found that the list of government contractors is not necessarily based on quality of work, but in the quantity of work, the size of projects that they've completed. And when it comes to quality, that is what really counts, and that is what my reputation is made or lost on. And it will happen, it has happened that people will visit projects that I have done and say, but you know, how could the architect accept this work? And the answer is simple, I did not accept it. I listed it as a defect for the contractor to make good. And maybe they never did make it good. And I end up carrying the arm, getting the blame. But this is a law of contracts and construction. So, and if the client hopefully will see to it that it is made good, but at whose expense? And then again, this brings back the point of the fine line that the architect must walk, because if you know your contractor and you will allow them the ability to make good these defects. But if it's an unknown quantity who you're working with for the first time, who you may decide not to accept the project, although it's very nearly complete until these things have been totally made good. Now, beyond the defects liability and maintenance period and the final inspection, there is no legal means for the architect to have a contractor make good any defect that might become evident. But it would certainly suit him or her well to act as an intermediary, nonetheless, between the owner and the contractor to seek to have the defect rectified. There will always be a recourse for the owner to go to the courts to seek compensation for defective workmanship or latent defects on the part of the contractor. Interestingly, and this ties in with what a point Alton raised earlier, if it is thought that the architect knowingly and willfully omitted to list the said defect during the course of the contract and his or her inspections, then the architect might also be held liable for the cost of repairs. So this is why, you know, people must use certified registered professionals. This is not something to be taken lightly. And getting down to the end here, closing, I'd like to mention that there are two other forms of practical completion. One is sectional completion, and the other I would refer to as owner certified completion. Now, the first term, sectional completion, is pretty self-explanatory, as any project may be divided in portions or stages. And before practical completion of the entire contract, the owner may take possession of a portion of the work with the consent of the contractor. The architect shall then provide an estimate for the value of this portion of the work so that retention payments or damages that may come due can be adjusted accordingly by a ratio of the value of the total contract to the value of the total contract sum. Interestingly, and this leads directly into my next definition, practical completion of the relevant part occupied shall be deemed to have occurred. See, once they move in and use it for the purpose intended, all right, okay, the latter term, that's owner certified completion. As far as this is a term that doesn't appear in any textbook or construction contract. But despite my emphasis on the sole authority of the architect, there is a way for the owner to overrule the architect. And although this is highly inadvisable, the owner may decide to move in on the contractor and occupy the entire work site prematurely. Now, what happens? I'd ask the lawyers this question. I've had occasion to advise clients that such an action would, given the stated definition of practical completion, being that the owner may occupy the work or designated portion thereof for the use for which is intended. The contractor would have a strong case if they were to suggest that the owner, by occupying the building, by their actions, taking over, have themselves certified practical completion. And this was addressed in the latest form of the Construction Industry Council's contract, and specifically in clause 15, where a project is less than 95% completed, almost but not quite. The employer may request the architect or contract administrator in writing with a copy to the contractor to issue a certificate of practical completion. He or she shall forthwith issue a certificate to that effect, and practical completion of the work shall be deemed to have taken place on the day named in such certificate. To me, this clause abrogates the authority of the architect, but as it requires instruction in writing from the client, it may also release him or her from any future liabilities, issues that may arise. And these are just some of the issues that I have highlighted here for you. I don't know if there's more to be added, but I am certainly open for further discussion. Thank you.
Thanks, Bob, for that presentation. I don't think we suffered from any lack of PowerPoint. I'm going to say, Bob, in my own way, that we are at practical completion of your presentation. And after the break, we're going to have a defects liability period where you will be joined by some panelists, Mr. Robert Woodstock, Dr. Patricia Green, and Mr. Earl Samuels. So on the other side is short commercial break. We're going to be in the defects liability period for about half an hour. Everyone stick around and we'll be right back. Thanks, Bob.
Capture all the sweet moments in your own sweet home. Up to 100% financing from JN Bank will get you there. Get pre-approved now. JN Bank will help you find a way.
I light up the streets, I light up the beat, I light up the place where we meet and greet. Half of what they think, then we make life sweet. I light up the church where the pastor preach. Light up the good times in the service, power the music in the worship. Light up the moments that matter, light up the laughing and chatter. Light up the net and the rocket, light up the score so you know who got it. Power the socket, now stop it. Light up the path so you don't lose your way. Light up the field so you don't miss a play. Every night, every day. Light up the path so you don't lose your way. Every night, every day. Light up the field so you don't miss a play. Every night, every day. Light up the party from now till it's done. Every night, every day. Bringing light to everyone.
The Guaranteed Purchase Program is an initiative of the NHT to bring more houses faster to contributors. Under this agreement, the NHT will purchase housing solutions from developers for resale to its contributors. The GPP offers win-win solutions for everyone, the developers, the NHT, and most importantly, the contributors.
DigiView Security Limited. Operating for almost 15 years, DigiView Security Limited is one of Jamaica's premier electronic security solutions providers. DigiView offers top-of-the-line solutions and services to protect your home and business in the ever-evolving electronic security industry. AI features: perimeter protection camera, human detection and line cross, license plate recognition, panoramic 180-degree camera, 360-degree camera, face recognition, intelligent search and playback functions. DigiView Security Limited. See what you've been missing.
Welcome back. I'd like to introduce the panelists who will be joining Bob. The first is Mr. Robert Woodstock. He is a managing director at Harold Morrison and Robert Woodstock Associates Limited, a design-oriented architectural firm based in Jamaica and Barbados. He studied architecture at Cornell University, graduating with top honors and winning prestigious awards. He joined Harold Morrison and Associates in 1985 and has remained with the firm since then. He has received several accolades for his contributions to architecture in the Caribbean, including the Caribbean Building Awards Honorary Award and the Honorary Membership Award from the Trinidad and Tobago Institute of Architects. Mr. Woodstock is actively involved in various architectural organizations and serves as the chairman of the Architects Registration Board of Jamaica. He has worked on notable projects such as the Faculty of Medical Sciences, the Merlene Hamilton Postgraduate Student Housing, and the Normandy Law School Extension. His designs also include the G West Medical and Dental Complex, the Port Authority of Jamaica's Business Process Outsourcing Buildings, and the Fisherman's Village Redevelopment Project. Also joining the panel is Dr. Patricia Green. She's an architect and historic preservationist, and she's the principal of the firm Patricia E. Green Architects, and with an expertise in city regeneration using historic urban landscape approach. Working extensively across the Caribbean, she is UNESCO's international consultant on cultural heritage. An independent scholar, she is the former head of the Caribbean School of Architecture at the University of Technology, Jamaica. And I understand the final panelist we have is Mr. Earl Samuels. I think we met Earl earlier, and I think I'm going to describe him as a banker who has an extensive involvement in the building and development industry in Jamaica, but not an architect yet, Earl. Again, and for those who are joining, you can put your questions in the chat, or you can raise your hand and ask a question to the panel when you're identified, and you can always introduce yourself. And if you have a particular person you'd like to respond to your question, you could feel free to indicate who that person should be. I saw some questions in the Q&A earlier, and I think that they have been purged. So if your question is still burning, please put it back in the Q&A or do raise your hand. And while people are getting their hands raised, I would ask Bob, or I think Robert, who is both are involved in the Architects Registration Board. Do you, as an association, have a form of disciplinary process where either clients of architects, or let's say third parties who have no contract with an architect, can make a complaint to the regulatory body, and the regulatory body looks into the complaint and the conduct of the architect?
Yes, we definitely do. And just to educate those who may not realize the difference, there are two bodies. One is the Architects Registration Board, which is set up in statute based on the Architects Registration Act. The other one is the Jamaican Institute of Architects, which is a private association. Both bodies have codes of professional conduct, and both bodies have disciplinary committees and disciplinary procedures.
So your body would be akin to the GLC regulator of lawyers.
That's right. That's the Architects Registration Board. And then the
have you seen anything that we thought may be happening where people complain about the behavior, the professionalism, complaints along those lines?
Yes, usually related to the architect's role during contract administration, but also questioning the various architectural stages and what sort of drawings should be produced when. While we wait on questions, sorry, Krishna.
Go ahead, Robert.
I was wanted to pick up on some of the things that Bob had said earlier in his excellent presentation, and having to do with practical completion. And as the topic is really complete certificates, it would not only deal with the practical completion, but also the final certification. There are very slight differences between the excellent definition that Bob gave and what is actually in the Construction Industry Council's standard contract for building works, and also the JCT in the UK, from which our body originally took our contract. So one of the things is that in 2007, the CIC modified the section on practical completion. And as Bob correctly pointed out, and I believe maybe incorrectly, added two major clauses. One, which was where it wasn't practical or in the interest of the employer to have defects remedied. And the second one, to deal with instances where the employer had requested practical completion. And I think that one in particular is quite dangerous. Firstly, in terms of the definition, the distinction that I want to raise in the CIC, where it says, it starts off with, unless the parties shall have otherwise agreed, which means that the parties obviously could have agreed something else. It says practical completion shall be when, in the opinion of the architect, the works or section shall have been completed sufficiently to enable the employer to utilize the works for the purpose for which it was designed. So there are slight differences in the definition. To note that the JCT contracts are a lot more vague in the sense it just says, when in the opinion of the architect, the works are practically complete, or when in the opinion of the architect, practical completion of the works is achieved. But I want to just to touch on the portion dealing with the employer taking over the building when it is not ready to be taken, or it's not practically complete. And I want to quote from a professional liability book for architects, where it speaks to third parties, and I think Earl would probably be interested in this, where it says the third party's interest in the certificate of practical completion is probably greater than that of the original building owner or client. And he will, in truth, be relying on the skill, care, and integrity of the architect in issuing the certificate. And he says the importance of this cannot be overstressed, as no matter how willing the builder and the building owner may be to agree some sort of compromise over completion date or acceptance of substandard or incomplete work, the architect's duty is clear. The principal architects to the contract may not like it, but it is critical. And it is no use even accepting an indemnity from them on this point. And it says the dangers are far too real.
Absolutely. And before Bob responds, Robert, is there a common understanding of being practical, complete, and habitable?
May I just add a point, please, before both Bob and Robert? Bob, thank you for your excellent presentation. And Robert, your addition is important. But it's critical for all of us to understand that there is a contract, and you're talking about a specific terms of reference for the professional. In other words, in a development project, the contract, the architect's contract may have been specific to certain items or whatever. And so therefore the practical completion would, and the certificate would be with regard to those specific items under the architect's contract. So I think it's very important for us to establish that so we understand the parameters within which this certificate is issued, as opposed to expecting the architect to take responsibility for other things. For example, if you have a development, the actual access road and retaining walls may well be outside of the scope of the architect's work, but interrelated, but not specifically part of the practical completion of the architect's responsibility. So I just wanted to add that to what is being discussed.
I suspect that a lot of these developments that are going up, there is no architect involved in the final stage of the project. An architect may have done the drawings, an architect may have gone as far as getting the approval, and it happens that that's the end of the architect's involvement, and they don't need you anymore. And
so who issues the certificate of practical completion in the situation?
Whoever is named in the contractor, it could be John Brown, I mean, who might not have any professional qualifications whatsoever. And that's unfortunate. I mean, that's something that you as a financier and anybody else involved in the tail end of the project needs to insist that these people are registered professionals.
I'm happy for this discussion.
Not just the tail end, Bob, but at the very beginning. If you are financing a particular development project, and we're hearing Jacksonville being mentioned, and you're signing off on particular locations and environmental conditions, whether it be a sinkhole or a site that is traditionally a sinkhole, first rainfall, it floods, water is rising up out the ground. Then before the financing is done, you need to ensure that you have a professional team. And the professional team is responsible for the handing over and the direct development and handing over of the project. That's how we work professionally, and that's how it is done in what we call Jamaica, should be in Jamaica and other civilized environment.
But I also, Robert, thank you. I think we're in total agreement that this business of the owner certifying completion, it should never have gotten into the contract. But there it is. It's properly worded that the owner would instruct the architect in writing. And I think the lawyers have left us now, but I think that definitely will. No, there's still there.
The thing about in writing was probably to try to protect the architects, but I'm not so sure that the architects protected.
Yeah.
And particularly the CIC, which says for the purpose for which it was designed, I would go a step further and say probably that's why it's probably best to have an architect as opposed to even other qualified professionals as it relates to building projects.
So the unsuspecting purchaser is at the mercy of everyone, which is unfortunate. What we have had to be doing.
I don't think that's a fair statement, no. Because we do have regulatory authorities. And so the purchaser and the developer and the communities, the citizens association, are really, the accountable agency in the land are the regulatory authorities. So it is ultimately the onus is on these regulatory authorities to ensure that the proper due diligence is done. Now, when at the end or the beginning, the financiers come into play, then you become the kind of second tier or the second level of certification and approval.
So we have to educate the purchaser.
Well, I'm not sure I agree with Pat entirely, and I'd like to mention that in the new Building Act, there's also this animal called a certificate of occupancy.
Right.
Which will be issued by the municipal authorities.
Yes.
So, as somebody who faces with them repeatedly, I'm not sure that they have the competency.
Bob, may I answer the question, please? Because I have the 2018 Building Act open in front of me.
Yes.
In the 2018 Building Act, there is a definition of what is called a building professional. The building professional is the architect or engineer or quantity surveyor or land surveyor. All of these persons comprise the building professional. And as, former head of the Caribbean School of Architecture, we tell you guys know, because you have been there as lecturers and reviewers and all kinds of things, that every student at the Caribbean School of Architecture knows that until they have gone through the proper training, the bachelor's, the master's, and then their practical completion, and then do their exam, they are not allowed to call themselves architects. So everyone who has gone through that kind of architectural training, whether locally or internationally, they all know this. But what the safeguard, and this is why the authorities have the responsibilities, it says, under the definition, it says a building practitioner means a person other than a building professional or a building official. So if you're not a building professional, you're called a building practitioner. And it gives the definition of building professional. It means a person other than a building official or a building practitioner. So a professional other than a building official or a building practitioner who is engaged in or supervises building work, any phase of building work or the supervision of a building, and who is registered, and we have the president, the chairman of the registration board here, licensed or otherwise authorized to carry out the performance. And then we go to section 18, clause 3 of the Building Act. It reads, the certification referred to in subsection 2, which is just above, is the certification by one or more building professionals, or in the case of small building work, building practitioners who carry out or supervise the preparation of the building designs plans in relation to the proposed building works. So the Building Act actually defines the professional who is going to be doing a multi-story or a building practitioner who is going to be doing what the Act terms as carrying out small building works. And when you look at the local government website and the guidance, it says a building practitioner and a small building works is defined as anything under 300 square meters. So when we have developments which are being undertaken by persons who are outside or who are not designated under the law as a building professional, then we have the regulatory authorities who should be the first recourse. And every neighborhood has to ask, why is it that an approval has been given, which is against and contrary to the Building Act? And the Building Act is modified and monitored by the Jamaica Bureau of Standards.
I agree with your Pat as far as the engagement of professionals, but I also have the Building Act in front of me, and it says that the whole or part of a building, as the case may be, shall not be occupied until the local authority has issued a certificate of occupancy in relation to the whole or part of the building. So all well and good, but at the end of the day, they can say, okay, it's finished, it's done.
I agree with you.
Can I come in here?
Yes.
Yes, all right. Dr. Green is correct up to a point. One of the difficulties we are encountering with the administration of the Building Act is that the regulations in relation to the panel that must certify building practitioners, those regulations have not been defined and the panel has not been created. So that's one. The minister has dropped the ball on that, and I'll say it bluntly, because the act has been in operation since 2019, and that important feature of the statute has not been dealt with. That's one. Two, as I said earlier, it's a contract that the architect has. Most people don't understand that the primary contract is the design and approval of the building. The monitoring of the construction is referred to commonly in the profession, I think, as post-contract services. Am I right on that?
No, but that's for quantity surveying. But for architects, what we call normal services includes everything from the brief to the completion of the work.
Okay, fine.
I
And that's
prefer,
what is normal architectural services.
I prefer
JDA conditions of engagement.
and also I prefer the definition of that stage as contract administration, because
okay,
it's not contract supervision. It's not that the architect is physically present on the site to watch and see how the work is executed. We see that the contract is administered in accordance with
the design and the approvals, right?
Correct.
So there needs to be that clarification and understanding generally. But we do have a bit of a conundrum in terms of how the law treats with it. The agreement between the owner of the property and the architect is a private contract. There's a separate legislative overlay in relation to the approvals. The architect ensures that the building is constructed in accordance with the approvals.
Absolutely.
We are seeing a problem, however, of plans being certified for approval, but the architect who certifies them is not around at the time of construction. And then the certification that it's completed, practical completion, is not referred to that architect at all.
Right.
So I would say to the financiers, they should check to see who was the architect that certified the plans and insist that that architect must also sign the practical completion certificate before they accept it.
Excellent point. And especially when in the CIC, it refers to for the purpose of which it was designed. The word designed is actually in there.
That's right. Yes, quite so.
Well, the practical completion certificate and the occupancy certificate. The occupancy certificate comes after the practical completion certificate. Yes. Is that it should.
It probably will. It probably
yes,
will.
that's the one on the Section 34, the Building Act. You know, I've never seen one.
But I've never seen how
I've asked.
Is this a feature of the voting where occupancy certificate are issued? That
it is very important, and I'll.
Yes. But Pat, it is important, but they're not issued before the building is handed over to the purchaser.
It should be, and you need to ask for it because it's under the Act. And the certification of occupancy includes things like what Bob mentioned earlier. Has the fire inspector approved this? All the various issues like the Ministry of Health in terms of your storage. And you have to, those are the things that say, yes, you're ready for occupancy. But may I have an opportunity to respond to Mr. Morgan, please? Alton. You mentioned.
Please go.
Yeah, thank you. In the Building Act, it gives a definition of a building professional, and it gives a definition of the building practitioner. I agree with you, and I have been in discussion with the Bureau of Standards about this whole definition of the building practitioner. And I do agree with you, and you are correct. However, the definition of a building professional, meaning the architect and so forth, is indisputable. And so we are talking about two separate things, and two separate, and there is no need for any regulation or any board to establish what's the definition of a building professional, because we do have an Architects and Registration Act and an Engineer Registration Act. So that is established. So in the context of the approval system and the administration of the Building Act, we have the definition established. So we don't have to have a debate about what's the responsibilities. It says that small building work should be carried out by a practitioner.
Oh, yes, it's all a matter of interpretation of the statute. And as I made the point, one is a contractual arrangement and the other is a statutory arrangement. So the occupancy certificate is a statutory arrangement. The practical completion certificate from the architect is a contractual arrangement. But the occupancy certificate is like a SIPTID, a legendary creature that nobody has ever really seen, you know, the unicorn or Bigfoot, the Yeti. So until the local authorities decide they're going to obey the law and issue occupancy certificates, we are left to wonder, and they are the only ones who can issue those certificates.
And also the purchaser is at the mercy of the professionals, the developer.
If the professionals are involved throughout the construction, throughout all stages of a project.
Correct, Bob.
I cannot overemphasize that, because it happens that at one point we may be dismissed because they think they're saving money. So they can, you know, then they know how to build, they can do it themselves. You got the drawing, we have the drawings. Thank you very much.
I've seen practical completion certificate and I send my officer to go and inspect because of the complaint from the prospective mortgager. Kitchen cupboards not in. Some of the bathroom to be tiled and so on. How could practical completion certificate be issued for a project like that?
It should not be so, because it is not, it cannot be used for the purpose intended. Simple as that.
But the certificate is issued.
Well, find out who issued it.
The certificate is illusory, actually.
If it's an architect who issued it, you can go to the architect's the disciplinary committee and we can register a complaint against that if it is an architect, but I doubt that very much.
And
what I would recommend,
we were careful, Bob, to show us, and thank you for doing that, what an architect's practical completion certificate looks like. So maybe we should be sending one as architects to all our financiers and building societies so they recognize what it looks like. And, you know, because maybe that's one of the things that's needs a part of our educational process.
It should also bear the client's signature.
Well, that's an interesting one, because as one of the persons who developed that form, it was from my American training. We took it from an AIA form, and that is totally different from the RIBA and the JCT recognized form, which only has the architect. And in Jamaica, I haven't had an issue, but I had a major issue in practicing for the government in Barbados, where they refused point blank to sign it, and they said under the contract, the architect is the person in charge. Only your signature should be on it, and I had to take it off of the thing because they want you, right? And we had to use a form similar to the RIBA form. But I think certainly in Jamaica, where it is useful and helpful to both client, contractor, and architect if all three parties can sign, because there can be no disagreement later on as to what, you know, when practical completion was and what, if any, outstanding items were left.
So
but I think
you really want full attendance for the inspection.
Yeah. But I want
if the occupancy certificate system was operational, was in place, then I think a lot of the challenges that we have would be through the window.
Well, Earl, you know, there's a simple methodology you can employ to make that occupancy certificate appear. Make it a condition for disbursement of the mortgage loan proceeds, that the occupancy certificate must be produced. And I am reasonably confident that the developer is going to go down to the local authority and make sure that he gets his occupancy certificate if he's to collect the sale proceeds to complete the transaction.
I agree with you, Alton.
Interesting.
That will have its own problems too, because you know how the municipalities don't have inspectors. So
if I may come back to the whole matter of practical completion, because we as architects, we have a certain thing in mind. We have certain definitions. We have gone a little bit beyond the JCT, but the attorneys and the judges in particular have made certain definitions. And there was a recent one in 2019, which I think is probably the standard now and confirms a ruling from the Hong Kong final court of appeal, because there were judges in England that had varying degrees in terms of how they interpreted practical completion. And if I may read some of them, one says, one would normally say that a task was practically complete when it was almost but not entirely finished. But practical completion suggests that it is not the intended meaning, and that what is meant is the completion of all the construction work that has to be done. And another one by Salmon LJ, completion for all practical purposes is to say, for the purpose of allowing the employers to take possession of the works and use them as intended. If practical completion meant completion down to the last detail, however trivial and unimportant, then clause 22 would be a penalty clause and as such unenforceable.
Vexatious.
And then there was, in the House of Lords, they said practical completion as being the absence of any patent defects in materials or workmanship. And so the this, I think up until the ruling in 2019, which I think reaffirms the case of the Hong Kong
right
of the Hong Kong final court of appeal, which basically states that sorry, I wanted to read the section. The Court of Final Appeal in Hong Kong appears to agree with Keating, and Keating had four things that he said. The works can be practically complete, notwithstanding that there are latent defects. And latent defects are effects that obviously you can't see at practical completion.
Right.
Certificate of practical completion may not be issued if there are patent defects. The defects liability period is provided in order to enable defects not apparent at the date of practical completion to be remedied. Practical completion means the completion of all the construction work that is to be done. And this is the important part. However, the architect is given a discretion under clause, and I'm quoting from JCT, to certify practical completion where there are very minor items of work left incomplete on de minimis principles. And then in the Hong Kong Final Court of Appeal ruled that practical completion was a legal term of art in building contracts, and that a term in building contracts means a state of affairs in which the building has been completed free from any patent defects other than ones to be ignored as trifling. And finally, the 2019 case in terms of Mears and cost plan.
Cost plan, yes.
Yes, that has 6 things that I think we need to, as architects, bear in mind. 1, practical is one we already know. Practical completion is easier to recognize than define. There are no hard and fast rules. 2, the existence of latent defects cannot prevent practical completion. Again, obvious. 3, in relation to patent defects, there is no difference between an item of work that has yet to be completed, i.e. an outstanding item, and an item of defective work which needs to be remedied. 4, practical completion is a state of affairs in which the works have been completed free from patent defects other than ones to be ignored as trifling. 5, whether or not an item is trifling is a matter of fact and degree to be measured against the purpose of allowing the employer to take possession of the works and to use them as intended. Although the fact that the employer can take possession and use the works as intended will not always mean they are practically complete. And finally, the mere fact that the defect is irremediable does not mean that the works are not practically complete. The question remains is whether the defects are trifling in nature.
So Robert, if we hear from Earl, there's a kitchen cupboard that is missing.
Not trifling.
Well, I will give you, if I can find it, in that same case, because the matter had nothing to do with practical completion initially. It had to do with something else, and then
the size of the rooms.
Right, and the fact that 58 of the rooms were under the 3 were less than the 3% that was allowable in the contract.
Correct.
But the attorneys can explain that. But in the
so is it the kitchen cabinet, was that a part of the design?
Well, in the decision, which is for me frightening, but you see the judges, they speak to the judge who wrote the ruling said that he spoke about not kitchen cupboards. He said if a floor was missing, right, that in his opinion would stop it. And then he said, but what if it,
which is structural? The floor is structural.
What if it's just a patio that's missing? Is that trifling?
No.
So what we're
all architects will say it is not. You know, it has to be there. But the judges may.
Earl, is Robert saying that in terms of the architect and the architectural responsibilities, there are some structural components. Cupboards are like fittings and fixtures and so on. So the question is, was that part of the architect's contract? And is it that just a scenario, because these things, you know how these things work. Okay, you build a building and I will get somebody from a kitchen person to come in and put in the cupboards. And so you may not know the details of the intimacy of the contract between the architect and the developer or the contractor. So therefore you have the architect's responsibility. So in terms of the practical completion, the structural component was there, the floors were there, the size of the room, all the outlets in the walls for the various things, and somebody else is to come in, a subcontractor, who will be coming, not falling under the architect's certificate or contract to handle those things. And those are some of the questions that are important that you as a financier should be asking.
So now, Pat, I need the occupancy certificate. The certificate of practical completion is it is important, but more important to me is the occupancy certificate.
Remember, I say the occupancy certificate includes your sewerage. So therefore, the Ministry of Health, the environmental unit, needs to sign off that the sewerage, if you have an apartment that is designed for 4 habitable rooms, and suddenly it has become 8 habitable rooms, is the sewerage sufficient to facilitate 8 persons, 8 habitable rooms, or 4 habitable rooms? And that's the certificate that the KSAMC needs to issue, that all the criteria, including the environmental components, the drainage, the sewerage, are complete. So it includes the architect's practical completion certificate, but it needs to have other kind of compliances. Egress, access and egress. Has NAA signed off on the driveways? I mean, do you have your driveway on a corner? And this, the architect may not have designed it to be where it is now. But when you look at the original plans and what is built, then that's where the certificate comes in. I hope it's helping, Earl.
It is helping me. And so, because I have to protect my security.
May I make a small point? This has been brilliant, this discussion. I'm thoroughly enjoying it. I missed a few pieces though, but I didn't want to say anything at all in this part of the discussion. But on the issue of the certificate of occupancy, there is a very key component of the legislative framework that is still missing. And if you were to look at section 34.4 of the new Building Act, it says the local authority shall issue a certificate of occupancy in relation to building work if on application by the owner. And I will pause there and say, Dr. Green, you're absolutely correct. It's not just about the architects at this point. It is the owner. It is the entity, the person responsible for the entirety of the development, which will include components that are outside of your responsibility. So on application by the owner to the local authority, which would be the KCMC and all the other municipal authorities, the authority will issue that certificate of occupancy if satisfied that the building work has been completed in accordance with this act, the Building Act, the National Building Code, or any other regulations made under this act, and it goes on. So there's an entire legislative scheme for the building laws to be operationalized. Our national building codes don't exist as yet. It is modeled off the international building codes, and I think you all understand how that will work, the application documents and all of that. That is still outstanding. And it's an issue that comes up from time to time, both in discussions, erudite discussions such as this, as well as in the courts. And the point has to be continuously made that the authorities across the island can go so far and no further with certain things, certain responsibilities imposed on it under the Building Act. Because in the absence of the National Building Code, which includes the codes for everything, the small building codes, the electricity code, the water, the sewage, everything that will now fall under these codes, they are still outstanding.
But thank you so much, Mrs. Bennett Cooper, because we do have some things that are already in place. And so I am very much in favor of let us use what we already have. And I keep giving the example of sewerage. In the case of the development, I think it's Belgrave, Alton, where the judge went and they found that there was a whole discussion on the sewerage of the property when you read the court case. And where is the sewerage going to be offloaded? Was it going to be sent into the gully? Was it sent into a central sewerage system? In fact, a central sewerage system is precedence number one for any multifamily development, and many of them are taking place where there's no central sewerage system. So we need to be saying, okay, we know things have to be done. We know that there are certain things that are still under discussion, and I'm keeping in touch with the Bureau of Standards because they are one of the major authorities in developing these things. So I'm aware of the deficiencies, but we have things like central sewerage.
But shouldn't that be a part of the whole approval?
That's what I'm saying, Earl.
It is.
Therefore, your certificate of occupancy must ensure that you do not exceed the habitable room you're granted. And if you do, then you need to change your
unlawful. But the certificate would be unlawful. It would fail to comply with the law. The law says that you will issue it when you're satisfied of certain things. You cannot want to say that you're satisfied that there's compliance with the building code if there is no code. So unless we would wish to make a recommendation to the authorities that they issue a certificate that says you're in compliance with these things. However, the caveat is that we are not able to say, I'm not sure how it would fit within the legislative framework, just from speaking from a lawyer perspective. And sometimes we are limited because we have to say to every entity, you can only act within the four corners of the legislation. Otherwise, it's ultra virus. What would be the legal validity of a certificate of occupancy that fails to say what the law says it should say? And I do not have an answer. And it is something that
So certificate of occupancy are not issued at this time. Is that so?
So unless they issue one which adds the caveat that these things are missing, it's something to which Dr. Green I have given thought, and I'm not sure exactly how we respond to this, because the National Building Code really should have been in place in conjunction, hand in hand with this act, hand in hand with the regulations. We should not be in 2023.
I think.
What is the role of JDA to ensure that this is done?
Why are we doing development?
Yeah.
Well, can I make a comment? I think one of the problems is that the approving agencies have been giving approvals for density in anticipation of the installation of major sewage works. Classic example we saw of that was on Millsboro Avenue, which has become very much a high density. One single road has had its density accelerated over the last 5 years. And it's only very recently that the sewage line was put in. But you see, the logistics now become part of the issue. Do you put in the sewer line first, or do you put in the development first and then connect the sewer line afterwards? I'm of the view that if the facility does not exist, then you can't get the approval validly for the density that you would want to, which is only available when the sewer line exists. And that's part of the problem we're faced with.
I'm so sorry to cut you off. Bearing in mind, though, that the Planning Act allows you to do development in anticipation of certain things in terms of the law. The Building Act, which is the one that makes reference to the occupancy certificate, does not give you this kind of loophole, if you will, or cushion.
Precisely.
Laws do, but not the Building Act. So what then has been happening is a workaround. The legislations that give you a complete approach to dealing with the developments, you've been anchoring on that. But the new Building Act is flawed. I wouldn't even mention the difficulties with the regulation, because at least the new Building Act says that you can rely on the old regulations. But in the absence of a document that many of us have seen, called a Building Code for Jamaica, which is a policy document, not a document recognized by this legislation, there are no codes, and it's a problem.
Doesn't the Building Act refer to the code?
It does.
Yes,
but I could refer, but it doesn't yet. It's not yet a legal instrument, the building codes.
And thank you, Rose, for answering my question.
The regulations have not been promulgated.
Sorry, Robert. Thank you, Rose, for answering my question. Why are we doing development? Because there is the Town and Country Planning Act, which allows for development. Yes. And there are certain instruments and tools involved which will facilitate development. And I am very much for development and seeing development happening. But what needs to happen is that the criteria for this development needs to be fine-tuned. And what I think is missing is the responsibility of the various agencies during this process. So therefore, if there is a situation that you need a certificate of occupancy, then I believe it's the responsibility of the agency to begin to craft something and begin to have this discussion among the professional bodies and all the other people as an important item, so that institutions like JN Bank and others can begin to work with it. We do have a lot of things in place in this nation to make it happen well. We have, I believe, refused to appropriate and apply these tools and these instruments for the effective management and governance of the development process. And that's what I think is happening here, why we're talking about a completion certificate, because that is critical. This, and thank you for organizing it, JDA. This is a critical issue in the issuing of funding, etc., before and after development, so that somebody can move into their house with a key and say it is mine and be happy.
And the banks can be satisfied that we have good security and good collateral for the loan that we have extended to the homeowner.
Absolutely. I know the codes were developed by the building.
Correct.
the
I would
building
like
act
to
came out in the
Alton,
United
sorry.
States. Go ahead, Krishna. Go ahead, Krishna.
Sorry, no, I need to bring this interesting panel to a conclusion because of time limitations. But I do think what Dr. Green has said at the tail end there is to try and make do with what we have, because it may be able, until we have something better in place, and we don't know when that will be, that we can operate a system where interests such as Earl and his bank and interests of purchasers in multifamily developments can be better protected while we do this kind of development. And I think when I turn over to Dayton as chairman of the JDA, I think he's well armed now with some of the issues that need to be raised with at a political level. For example, with Minister Chuck and others that need some attention in the most short term to bring some sort of better order to the developers, legislative framework and protect citizens. So with that, I'd like to thank the presenter, Bob Fowler, and the panelists, and I turn back over to Chairman Dayton to take us out.
Thank you very much, Krishna, and thank you so very much to the presenters today and the panelists who have contributed so greatly to this very stimulating discussion. And as Krishna just pointed out, we need to go through what we heard and discussed this morning, compile a list of action, things that need to be done. And Earl, like you, critically involved in this, because we don't want to drop the ball. We don't point, having this discussion again next year. Next year, this time, we should be talking about what we have achieved based on the discussions we had today. And thanks ever so much to all our sponsors who made it possible, to Minister Chuck, who started off this morning with such a detailed and impassioned presentation of what he sees as necessary for development. And of course, thanks to you, Krishna, for taking on the role of moderator and doing a wonderful job. And of course, Alton and Nisha and Rose, thanks again, wonderful. And Antoine and Earl for your contributions to as panelists, and of course, Pat and Robert this afternoon. Well, it's early, late morning for your contributions. And of course, we had JN Bank, Gore Developments, Gian, National Housing Trust. I think Earl set that precedent, and they have never failed us. And JPS, DigiView, Jamaica Money Market Brokers, Matalon Homes, Cement Company, Wicon, Millennium Properties, Jamaica Property Company, and Sagicor. Thank you ever so much for your sponsorship. And to our 280 odd attendees, many of whom have made a contribution, which will, of course, all of this will go towards our scholarship fund for the UTech students in the built environment. And we're very grateful for your contribution. Thanks to our planning committee, hardworking planning committee of Alton, Carolyn Chuck, and Leisha Ann, Caroline Simpson, our company secretary, and of course, Bertina Macaulay, our hardworking tech expert and guru, who kept the gremlins away today completely. Wonderful job, Bertina. Thank you ever so much. And so we thank you. Of course, in October, we plan to have another webinar. This time we're going to bring in the quantity surveyors and hear what they have to say about closing statements. I think that's that will be equally as exciting as the one as the issuing a certificate of practical completion. Thank you all ever so much. God bless, and have a wonderful afternoon and summer and life. Take care.